Good morning, everyone. Welcome to the Appellate Division First Department. We have oral arguments for today, Valentine's Day, February 14th. So please only ask for the time that you actually need in order to get out the salient points of your arguments. Please keep in mind that we are fully familiar with your arguments. We've read the briefs. We have the record. Also, please note that the light is for you, not for us. If, in fact, we have additional questions to ask, we will certainly do so. People v. James Rivera. (313) Rivera v. 454 West 57th Street.
Defendants appellants 6 and 2.
525. A matter of Stephen and Ayet. That matter is submitted. Hendrick versus Sewell. 415. Barcia versus Costco Wholesale. You don't have a respondent? Oh, you're 5252. Macabi Management versus Kaban 2356. Okay, 525. People v. Yousef Johnson.
Good morning. Appellants 6 and 2, please.
525. Tahari versus 860 Fifth Avenue.
Appellants 6 and 4.
525. Vavar, you see there's a pattern here? Vavar v. Citigroup Technology. Excellent. Very good. That's even better. 524. WV Partners v. Hudson Private.
Good morning, Your Honor. Appellants 5 and 2.
525. As I stated, if there are additional questions from the panel, we will certainly ask those questions. People v. Dane, Richardson. 525. Wong versus New York City Employees Retirement System.
Appellants 5 and 2, Your Honor.
525. Taub versus New York City Water Board. 5 and 2. Essential Home versus Rawson. Hi. There's no respondent for the 2. Excuse me? Fine. Matter is submitted. 2187 Units versus Stringfellow. That matter is submitted. Kalori versus Kalori. That matter is submitted. First case for argument is People v. James Rivera. Yes, whenever you are ready.
Good morning, Your Honors, and happy Valentine's Day. On behalf of James Rivera, Phoenix Rice Johnson. The instant offense took place when Mr. Rivera had hit absolute rock bottom. From the time he was 14 years old until the instant offense when he was 41, his life had been derailed by drug addiction, and he was living with untreated depression and anxiety. Struggling with all of these issues.
Were any of these, was this documented? Because I didn't see anything in the record about his anxiety, et cetera, mental illness being documented. I didn't see anything in the pre-sentence report concerning that.
I believe it is in the pre-sentence report, Your Honor.
Was it self-reported, or were there any accompanying documents from any medical physician or
To my knowledge, it was self-reported. However, it indicated that he was diagnosed with these issues in 2016.
Was there a pre-sentence report, was there a pre-sentencing report done by counsel?
No, there was no pre-pleading investigation.
You know, and also I wanted to say there are a couple of things that I found a little troubling in your brief. I don't know whether you did the brief, whether you wrote the brief or not, but I just wanted to let you know that New York City Housing Authority, it's not a facility, it's a development. Normally when we talk about a facility, we're talking about some type of correctional facility. Also, your statements that he somehow needed the weapon in order to protect himself because he was homeless. And you also made reference in your brief to the fact that there is crime in the New York City Housing Authority development. And so my question is, what did that have to do with him? He did not live in that development. He was trespassing.
Absolutely, Your Honor, and thank you for those corrections. I only provided that information to give context to how vulnerable, anxious, and out of control he likely felt, considering all of the...
Considering he was trespassing. So any crime that occurs at New York City Housing Authority developments is because of folks coming in, like him, with a gun and shooting someone in the head, I believe, right?
Yes, he did
Yes.
shoot someone in the
So
head.
again, he pled guilty to demand one. He was sentenced to 23 years incarceration for his 5 years post-release supervision. He did have a record, I think, in Florida?
Yes,
Yes.
he had a
So
record.
why is it that we should reduce the sentence?
Here, Your Honor, I just want to highlight that this is someone for whom every structure that is supposed to keep someone from falling through the cracks, from living a life of homelessness and drug addiction, failed him. He is someone who, although he committed an absolutely serious offense,
Counsel, the waiver of right to appeal in this case followed the model colloquy, so how is it that it wasn't sufficient to preclude our review of this, of the excessive sentence?
where is here someone is waiving their right to have a higher court consider their conviction, and that person is convicted of a homicide offense and sentenced to 23 years, the waiver must be absolutely crystal clear.
And why was it not absolutely crystal clear? I'm looking at the waiver. So, I'm looking at the colloquy by the court. Where in this colloquy, and also there's a written waiver, where is it not crystal clear? And also, he's represented by counsel, right? And I think at some point in time, he was asked whether or not he had spoken to his attorney concerning the waiver. But where is it not crystal clear?
In the court's colloquy, when describing an appeal, the court indicated twice that if he were to take an appeal without a waiver, he would have the attendant right to counsel. However, when explaining that if he were to waive his right to appeal and certain issues would survive, the court not once indicated that the attendant right to counsel would remain. Mr. Rivera's first language is not English, and in fact, if you were to view his recorded statement to police, it's clear that his English is quite limited. So when we're discussing something as complicated and legalistic as an appeal waiver, it's crucial that it be crystal clear, and here it was not.
And his counsel, again, he asked, the statement is whether you've discussed this with your attorney. The response was yes. At no point did the defendant state that he did not understand.
That's correct, Your Honor.
And I don't really see that there was a conflation by the court in terms of in terms of the right to counsel with the waiver of the right to appeal. I don't see that. But anyhow, you do have time on rebuttal. Thank you.
Thank you.
Good morning, and may it please the court, Aiden Sanchez for the people. I would just reiterate what your honors have all said this morning, and I would also add as to the sentence that defendant received, defendant was indicted for murder in the second degree, and if he was convicted on that charge, he would have faced up to life incarceration.
Have we ever said that the waiver has to separately say that, I mean, the waiver, the colloquy says, normally you're entitled to a right of appeal, you have a right to an attorney on appeal. Have we ever said that we have to say separately in this part, among the limited number of claims that will survive, have we ever said that the court has to orally say to him, and again, you get the right to, because the court did tell him normally you get the right to an attorney on appeal, right? Have we ever said that there's a requirement for this waiver to be good, that you have to separately say it again?
No, Your Honor, that is
And
not.
it says it in the written waiver, correct?
It does, Your Honor, and in the full context of the colloquy, it is clear that the court is saying there are claims that survive, and the defendant
And
can
he
use-
was asked if he spoke to his attorney and went through the written waiver, correct?
Correct,
And he said, yes, he did, and he understood it, right?
yes.
And one of the claims that the waiver specifically indicated would not survive is a claim of excessive sentence, correct?
Exactly right,
And he
yes.
said he understood that, correct?
Yes. Unless there are any further questions, I would rest.
Thank you.
on the brief. Thank you.
I would like to highlight that here, Mr. Rivera received a sentence of 23 years, which is on the extreme high end of the manslaughter range. If he serves the maximum of his term, he will not be released until he is 66 years old. I'm asking this court to consider the many factors in his life that led him to feel so out of control and so paranoid and caused him to act so disproportionately in giving him a second chance, considering that he has a young son and it is his stated goal to reconnect with his son and be present in his life upon his release. I have no further comments, Your Honor, and I'll rest on my brief. Thank you.
Thank you. Thank you both. Rivera v. 454 West 57th Street.
May it please the court, David Cheng at Kahana Feld on behalf of defendants appellants. This is a narrow appeal on a narrow issue. The case arises from Labor Law 241 Falling Objects Law, but the issue on appeal is about summary judgment law. Whether the plaintiff's prima facie burden was met on the record we have here. The elements of a 240 claim are well established, they're well settled by law. We're only here talking about two of them. Whether the pipe foreseeably required securing for purposes of the undertaking at the time it fell, and two, whether the pipe fell because of a safety device of the kind enumerated in the statute being absent or inadequate.
So, counsel, I was looking at the case law here, and it seems that the case law is pretty much against you. In Rzymski, screws and metal hooks were found to be inadequate safety devices where a side pipe that was previously installed fell and hit the plaintiff. What is it, Delcio, Wonder Board came off. It was screwed into a lobby wall the day before it fell on the plaintiff's head. And what else? Rivas. The trench walls required shoring. Why didn't the pipe require proper securing here? The testimony was that it was only screwed in with a bracket, I believe?
No, Your Honor.
Excuse me, screws and metal hooks.
Yes, Your Honor. The pipes were screwed together with screws and then hooked into the building with metal hooks. To answer your questions, we need to remember the posture that we're here on. This is a summary judgment posture coming off of plaintiff as the moving party. I'm not here asking for the case to be dismissed.
We're talking about a falling object, right? Pipe comes down, hits him on the head.
Yes, Your Honor. But all we're talking about here is there being a triable issue, and there is a triable issue.
What's the triable issue? And the pipe, they were putting up the pipe and it fell on him. What was the triable issue? Obviously, the screws and the metal hooks were not sufficient to hold up the pipe. So what's the triable issue?
Well, Your Honor, I have to disagree with you on that. I can't say it's obvious the screws and metal hooks weren't enough to hold up the pipe because we have no idea what the pipe fell, quote unquote, because of. No one witnessed the pipe fall. We have no other analysis of it. No one even looked at the pipe.
Does the case law say that in order to get summary judgment, you have to show the exact circumstances of how the object fell?
Great question, Your Honor. No, it does not require the exact circumstances be shown. However, they cannot be presumed from record silence, and that's what we have.
So what did you show? What did you show in opposition to summary judgment?
Your Honor, I do need to clarify. This is not. This is an Alvarez appeal. This is all about the plaintiff's prima facie case, and under Alvarez, we do not. It doesn't matter whether the defendants put forth.
Well, assuming that we consider, having read the record, which we all did, that the plaintiff established his prima facie case, what did you put forward that would show that they were not entitled to summary judgment?
Again, Your Honor, I'm limited by the appeal that we took. We did not appeal on that basis. If you find that a prima facie case was made, that's it, we're done, plaintiff wins. The whole thing is about the prima facie case, and as you said, Your Honor, he does not have to show the exact circumstances, but the record is silent. We do not know why the hooks...
It's not that silent. The pipe fell.
The pipe did fail. However, the law both of this court and the Court of Appeals is very clear. The fact of an accident alone happening is not sufficient. If you have the pipe fall, that's fine, but it still requires that the pipe required further securing for purposes of the undertaking at the time it fell, and it requires that the reason it fell be because
Why is it that the plaintiff hasn't established that? The first point.
because the record is silent. We don't know why the pipe fell. We don't know what it fell because of.
Plaintiff states why the pipe fell. The pipe fell because, according to the plaintiff, the pipe fell because it was not properly secured. So, but as my colleague asked, what did you put in to draw into question the pipe falling?
Again, Your Honor, this is not that kind of an appeal. We don't reach that question. If you find the plaintiff has made a prima facie case, we're done. Plaintiff wins.
Okay, thank you.
I saw the light.
Yeah, you said we're done. Plaintiff wins.
If.
May it please the court, John Shore for plaintiff respondent. As Justice Gonzalez noted in two cases, one of them, the Delsit case, I know this court knows, and I know Justice Weber and Justice Kaptic.
So what is your response then to your friend's argument that we don't even need to reach that issue if we find, as they contend, that that the plaintiff did not make out a prima facie case?
Obviously, the record is uncontroverted that plaintiff made out an uncontroverted prima facie case. In the record, pages 84 and 93, plaintiff said that this 10-foot long pipe that fell at a distance of approximately 7 to 8 feet was supposed to be secured. In fact, in order to install this pipe, they used a rope and a pulley to hold the pipe until it was installed. And counsel misstates the record. Clearly, this was an object that was required to be secured. The coupling was a metal bracket that was hammered in to the structure, so the 10-foot long pipe was supposed to be secured. As this court just noted, what did they provide in response? Did they provide an affidavit? Did they provide any testimony? They provided nothing. As the lower court noted.
I'm reading the lower court's, the Supreme Court's decision. It says defendants feebly opposed summary judgment and failed to raise a triable issue of fact.
Well, of course,
not to be that blunt,
he's
but
disputing that you made out your prima facie case. That's his argument before us today.
So, and specifically, he's saying that you didn't show that the pipe was adequately secured, was not adequately secured. So
Right, the
question is,
metal hook, right.
right, is it enough to circumstantially conclude that from the evidence that the pipe was being secured and then it fell?
it's
Right?
the law of logic,
Right?
Justice Scarpola.
The
Plaintiff
question is, does
testified
somebody
it was
have,
supposed to be
somebody actually
secured like the
have to
Wonder
see it?
Board in Delsid or the many other cases. They were supposed to be secured, but they fell.
So your response, I suppose, is you don't need direct testimony. You can find from circumstantial evidence that it was being installed, that they were actually putting in the securing apparatus, and then it fell. And from that, from that circumstantial evidence, it's reasonable to conclude that it wasn't adequately secured, even though no one actually, in fact, that's a trial, that's literally the trial PJI on circumstantial evidence, right? I didn't see the glass of water go over, but the judge is wiping the water off, and we all, right? So that's fair, right?
Fair enough, in addition to the testimony of plaintiff that he said it was supposed to be secured, and they used this apparatus and it fell. clearly it wasn't
There
secure.
was enough circumstantial evidence, is, I guess, what you're saying, that nobody actually had to look at it come apart and fall.
Absolutely, like in the Harasni case and the Milan case and many other cases that this court is well aware of. Unless this court has any other questions, I'll rest on my brief. Thank you.
Your Honors, there are 2 points that I would like to make on rebuttal. First, Your Honor, that is not entirely an accurate representation of the record that the pipe was being installed when it fell. It wasn't. Plaintiff admitted that it had been already installed, and because we are on a summary judgment, that's a direct quote.
But it was
Yeah,
already
but-
installed like a few moments before.
Like a
it
couple
fell.
minutes.
That is also not correct, Your Honor.
Wasn't the
that's
day
not correct.
We're here
before?
on a summary judgment posture. There is no evidence about how long the pipe had been there.
So,
That means that-
counsel, I think you're arguing counter to, I think it's PADOS, P-A-D-O-S, where, as you've acknowledged but are arguing to the contrary, the plaintiff is not required to show exactly how the pipe fell on him. I mean, PADOS is on point. This is where a rebar fell from up above immediately before the accident.
Your Honor, I'm familiar with that case, and it's distinguishable. The reason is because the rebar in that case was being actively worked upon by a worker above him. Here, we don't have that. This pipe had already been installed.
How long?
The record is silent, and because this is plaintiff's summary judgment motion, the inferences go in favor of the non-movement, my clients, the defendants. We have to presume, for purposes of a summary judgment motion, that it was there for the longest period of time possible, and that's since 8 a.m. that day when the work started. It was there for over half a day.
Let's start again. The pipe was installed at 8 o'clock in the morning, and it falls down and hits the guy on the head. That doesn't show temporal proximity to you?
No, Your Honor, because it acquired at least a triable issue of becoming part of the permanent infrastructure. We fall into
That
that
doesn't
body
work.
of law.
Del Cid goes against you.
I'm sorry, what?
Del Cid.
Sorry.
That's okay. It's okay. Del Cid goes against you. The pipe was not a permanent fixture.
Your Honor, that's
The work
actually...
wasn't completed.
That's actually exactly the other point I wanted to talk about, the Del Cid case. Del Cid is distinguishable. I see that the red light is on.
You may
May I
continue.
briefly conclude and
Complete your
answer your
thought.
question?
Why is it distinguishable?
First of all, posturally, what Del Cid was a reversal to deny the defendant's motion for summary judgment and find a triable issue. That's all we're asking for here. There's a triable issue of whether this thing had become permanent or not. There are issues of fact, as we've noted. We don't know how long it was here. I'm absolutely going off the presumption in favor of the non-moving party. We don't know how long it was there. A jury needs to determine that. The record is silent on whether it was being worked upon any further. I don't think it was, but unlike the Patos case where it actively was being worked upon, the record is silent. That's a triable issue there. Unlike those cases, we
Well,
have...
Del Cid, again, the Wonder Board was screwed into the lobby wall the day before. So I'm not understanding how you can say it's distinguishable.
Because
Go ahead.
you just said that this pipe was being installed that same day that it fell, that it was installed 8 a.m. and it fell that same day.
Well, Your Honor, the point that I'm making in that regard is in this particular regard, Del Cid is not distinguishable because it found a triable issue on this basis. All we're saying is that there's a triable issue, and when you compare it to other case law like the Buckley decision, which is cited in our reply brief, the fact that work was ongoing does not necessarily preclude that there is a triable issue. In Buckley, it was work on installing an elevator. The elevator installation was not finished, but work on the counterweight system had. The counterweights nonetheless fell and hit a worker, but it was deemed unforeseeable because work on the counterweight system
Also,
had
it's
been
apples
finished.
and oranges.
Thank you. Thank you both. Hendrick versus Sewell.
Good morning, Your Honors. May it please the court. Chet Lukaszewski for petitioner appellant Hendrick. Your Honor, it was a dry night. There was no snow. There was no ice anywhere. Saying any form of ice on the ground is expected
Well, I looked at the pictures. The pictures show ice.
Right, Your Honor, which
It
is why,
shows clumps of pieces and clumps of ice right by the curb.
right, not inclement weather ice, Your Honor. That's why we're saying this is a debris case. This isn't like where there would be rain and then ice would form. We're saying this was discarded debris, which was covered by the SUV. And if you read our breakdown, when the SUV is on top of the majority of the ice, there's 6 to 8 inches between the curb and what would have been the SUV's step up. That's where his foot was planted. On that strip, you see an even darker strip right next to the curb.
Yes.
So now you're imagining an SUV over the majority, shadow created by the SUV. Your Honor, this is a picture of a drawn back, enhanced photo of the scene. This is not my plaintiff's vantage point when he's getting out on an EDP call looking for a person in the area who's been harassing customers who could be a danger to himself.
The
This is-
photographs were provided by the plaintiff, right? Not
Sure,
by
Your
anyone
Honor.
else.
But go outside tonight, take a picture with your cell phone on normal setting. You're gonna see darkness. Take it on the mode where you wanna show, look, this is what the details of the scene were. He wasn't taking this to give the vantage point that he saw by the human eye. He was-
Counsel, are you saying that debris in the street is in most areas of New York City is sudden and unexpected?
Your Honor, I'm saying that he got out of his car, walked.
Yes, but
Right.
let me ask you a different way. Is it your position that debris in the street that's by a car is a sudden and unexpected thing that would cause an unforeseen accident?
I think debris, if it was trash, if it was something very readily observable in the light of day, would be an observable hazard. I think,
Ice cubes and these are pieces. This is not from
Giant
snow.
thing of ice. It's
Yeah.
a, it's
Your
a,
Honor, it's not though. You're looking at the picture
well,
without the
I
car.
even compared to the car.
I'm looking
No,
at
no,
the
but
picture.
Your Honor,
That's what, and I thought that's what the testimony was, wasn't it?
Your Honor,
That there
but
were
look at
pieces,
this- look
chunks.
at the-
I'm sorry, one second. These were chunks of ice, like large ice cubes.
Your Honor, if you look at the still frames of the video, 48, 49, 50, 51.
Yeah, I am.
You'll see where the SUV is parked.
Okay.
Those large chunks of ice were underneath the SUV.
So you're saying he wasn't really able to see them because you have to presume the SUV being over this, and that was the problem. Look, I read what happened below, and as we know, this was a 6-6 vote. This is an Article 78. That's the problem. It's not like a personal injury case where you're the plaintiff's attorney arguing for that, although someone was arguing, at the hearing. So the problem is here that there was a 6-6 vote. How do we find that this was arbitrary and capricious?
Right, but it's not 6-6, Your Honor. That's just the way the law breaks down the votes. It's city versus unions, and city gets the tiebreaker. So it's always 6.
But it's, yeah, okay.
That's what I'm saying. So what has to happen is you look to the legal precedents. And I think in this case, this is comparable, because if you're only looking at the ice in that small strip where he put his foot down, it's clear, it's nighttime, and again, we have to remember, he's on an EDP call. This is not just us, a normal day, looking down where we're stepping. He could be attacked at any moment.
But I mean, wasn't it looked at as though, I mean, police are on call, they're always on some kind of call. They're getting out to do they're checking for somebody. So they're looking for a disturbed person or an allegedly disturbed person in the restaurant creating problems. So they're always keeping an eye out for what's going on. That's part of what they do.
Your Honor, if I could just, yes, I agree, but this is why we can't diminish the protections of the pension laws. The Court of Appeals in Cambridge said wet pavement while stepping into an SUV. This court in Finazzo said a construction hole while stepping out of an SUV. There has to be some precedential effect, some protections of officers. It's going to be that every time they get hurt, they're denied the upper level of pension. They're going to spread the word that, look, don't even look around. Make sure you protect your ankles and your knees, and that's going to get someone hurt. And it's also going to trickle down to them telling their kids and their friends, don't join this job. You have no protections. If you're out trying to protect yourself and the general public and you slip on ice cubes that weren't there or you didn't see, you're going to be retired on a lesser pension. We're eroding the protections of these laws. This is not something, if you put yourself in the time and place, was readily observable. This is just us being pulled back and trying to look at the minutia. Put yourself in his place and tell me that these ice cubes in the dark, in this small crack, with an AEDP in the vicinity are observable, and I'm going to tell you that every single police officer will disagree with you.
Thank you.
Good morning, Your Honors. May it please the court. Shane Magnetti for the respondents.
So, counsel, if you would address the issues that were just raised by your adversary, under the circumstances where a police officer is responding to a 911 call that there's an EDP causing a problem, an emotionally disturbed person causing a problem in a restaurant, and the officer is acting in haste, why wouldn't this officer qualify for the higher level of ADR, accidental disability benefits, as opposed to the regular disability benefits?
And if I could just ask a question, I thought my reading of the record was that they got the call, they responded, they went to the restaurant, they did not find the person, and now they were so it's not like it was any type of, I'll use the term hot pursuit in terms of going into the restaurant. They came out the restaurant because the person was not there, and now they're going, I thought, to another call, and this is when the officer is getting back into the SUV. Is that correct?
That's correct, Your Honor. And Justice Gonzalez, I would say, because navigating hazards on foot as a patrol officer is an ordinary risk inherent in a patrol officer's job.
Would this plaintiff be considered, or petitioner be considered, a patrol officer if he's in an SUV?
Yes, he would. He pulls up in the SUV, he steps out of the SUV onto the curb, and he's responsible for navigating any trash or debris that might be on the curb, which is not unforeseeable. And I think you can look to this.
Is there anything about it being large clumps of ice that takes it out of the realm of ordinary trash and debris?
No, Your Honor. Whether the ice was naturally formed ice or whether it was part of the trash is immaterial.
But the argument is that the large chunks of ice or ice cubes were under the SUV, and therefore the SUV, partially obscured it, so that this is why he did not see it.
So the record does not establish that. If you look at the still images that counsel is referring this court to try and establish those facts, they're at pages 48 to 51 of the record.
Yeah.
You can't see the ice in that photograph. You can't see the curb in that photograph. You can't see whether the patrol car is parked over the ice or
So
obscuring
you're talking
it.
about like page 50, record 56, Exhibit D? Is that the one that you're talking about that doesn't let you see?
The still photos, I think
It's pages 48 to 51, the still images from the video surveillance.
right.
And you also can't see how far the car was from the curb. Counsel just said 6 to 8 inches from the curb. There's nothing in the record that establishes that. There's nothing in the record that establishes which chunk of ice he slipped on. And there's nothing in the record that would establish when that ice got there.
Ask you a different question.
Sure.
Do we treat a police officer who's responding to a 911 call along with whoever else is part of his team, do we treat him the same way as we treat a pedestrian who's walking in the street or crossing the street, who's supposed to be looking out to see, oh, there's garbage here, garbage there, walk around it, so on? Do we treat the police officer in the same way?
Well, I think you could, because I think it's not unforeseeable that you will have to navigate trash or debris on the curb of a New York City street. And I also think that 2 months ago, the Court of Appeals decided a case called Compagnon versus DiNapoli. It's at page 21 of my brief. And there the court held that petitioner's risk of being injured by an unseen hazard while investigating a potential crime in the dark was inherent in his ordinary job duties as a patrol officer. That's exactly what we have here. And I'd like to make one more point, which is about...
Before your time is up, let's get to the point, the fact that for us, we have to make a determination as to whether or not the board's determination was arbitrary and capricious. Your friend states that 6-6, it's always going to be 6-6. So how do we address that? Well, do you agree with that, and how do we address that issue?
Well, this was a tie vote. And when an applicant is denied accidental disability benefits by virtue of a tie vote, they have a very high bar to clear.
But he's claiming, he's arguing that it's always going to be, well, not always, but many times it's going to be a tie vote.
Many times, yes, it is going to be a tie vote, but that's simply the law that we have. And when that happens...
Is it a law or is it custom?
No, that's the law. That comes from Court of Appeals precedent. That comes from this court's precedent. Whenever there's a tie vote, the tie goes to the city. And then the bar to clear is that the record has to establish, as a matter of law, that this was an accident. And here, the record does not establish that. If you look at these photographs, you will see large chunks of conglomerated ice illuminated by storefront lights strewn across a wide area. And to the extent that counsel argues that these pictures don't accurately depict the conditions as they existed when he fell on them, I don't think that helps his argument. It was his burden to submit photographs that would accurately show the conditions. And the fact that they don't, I think, just underscores my point that this record is not sufficient as a matter of
Stop in
law.
the middle of a response to a 911 call and take pictures. Is that what you're saying?
No, he came back to the scene 20 to 30 minutes later. He could have parked his car where it was originally, and then that would have answered a lot of the questions that we have. That would have shown whether it was parked over the ice. That would have shown whether it was obscuring the ice. He also could have, in the various police forms he submitted in support of his application, given any more detail than just the bare bones statement, "I slipped on ice and injured my wrist." He could have described any of these conditions that he now raises on appeal without any record support. And without that record support, this record is not sufficient as a matter of law to find that this was an accident.
Thank you
Thank
very
you.
much.
Your Honors, respectfully, hindsight is unbelievable. He should have gone
Counsel,
back and
does the
taken dark
distinction,
photos.
in terms of the fact that this occurred as he was leaving the scene versus responding to the scene, bear any weight on the arguments you've raised?
Your Honor, the EDP was still in the vicinity. When they came out of that restaurant, they could have been walking into an ambush. I'm not being hyperbolic. In January 2022, while this case, in recent proximity to the case being tried, 2 officers were assassinated while sitting in their patrol car by an EDP. This is a real concern. Once they came out of the restaurant, on the video, you can see them still looking around. There is plenty of hiding spots on a crowded street. If an EDP leaves a restaurant, is not apprehended,
Well, the
he's
fact
still
that
in the
he's
vicinity.
looking around like that is more of a reason why he probably should have seen the ice, because he's looking all around everywhere to
Your Honor,
see
again,
what's there.
I just don't think that we're being realistic here. We're saying he should have gone back and taken dark photos. He wants to show what he slipped on. You're saying he should have looked around, right? Look
Well,
around.
no, I'm not
That's
saying
looking
that.
at your feet.
You're saying that. And
Absolutely. Around is like this. Down at your feet, you're just expecting there to be dry pavement or
in New York City, you're just expecting that there's no trash or debris as you're walking.
Again, Your Honor, when though is it enough? When are we not eroding the laws to where nothing is going to be an accident? He got out of his vehicle, was able, because he didn't put his foot on the roadway, he put it right onto the sidewalk, walked across a clean sidewalk with no ice on it, cleared the restaurant. Civilians okay. He's going back. EDP still in the vicinity. He's keeping his guard up as they're trained to do. This is the time where he steps down into the roadway onto ice cubes at night on a black roadway in the shadows with an EDP in the vicinity. I just don't understand how no one is putting themselves in that time and place to see that it's not something that you're going to see, like me going out to my car right now.
Your argument again is that the board's determination is arbitrary and capricious because they did not put themselves in the situation of stepping off the sidewalk onto the roadway before stepping into the SUV, put
No,
themselves in the officer's position of doing so.
I don't think they realistically, rationally, logically, all the arbitrary and capricious terms considered the circumstances of the event. I don't think they applied the Court of Appeals McCambridge case, the Finazzo case. I think to determine the accident, you have to look logically, rationally, realistically at all the factors. Of course, you can break this down 4 years later, and you can try and nitpick it, is to try and put yourself in the time and place of when the event happened and see the actual real application of the factors.
The motion judge, interestingly, said that she didn't necessarily agree with the result, but in order to be rational, the record must show as a matter of law that this was a service-related accident, and she did not believe the record did that. She indicated that she disagreed.
Your Honor,
So we're, whether we agree or disagree is really not the issue. Unfortunately, it's a very high standard on these Article 78s, as you well know.
there is one other I'm just asking Your Honor to look at the precedents, look at the Court of Appeals and this court's precedents, and look at the precedents applied by the lower court. In those cases, there was inclement weather, so ice and icy conditions could be expected. That was not the situation here, so now I think those ice cases are taken out, and this becomes a McCambridge or a Finazzo. If the Court of Appeals said the wet pavement and this court said the construction hole wasn't readily observable, then I don't see how these cubes in this shadow on this call can be said to be readily observable.
Thank you. Thank you both. Barcia versus Costco.
Good morning. May it please the court. Patrick Lawless for defendant appellant respondent Costco. The jury's verdict for future medical expenses was against the weight of the evidence. Dr. Guy's testimony as to the plaintiff's need for future medical care was wildly speculative and not supported by the record.
Are you addressing the issue of the replacement of the hardware, or are you addressing the issue of medication?
Well, I'm addressing the
Or
issue
both?
of, yeah, absolutely both. One of the examples of why Dr. Guy's testimony, which is the basis for the future medical expenses award, why it's so speculative and unsupported by the record is the plaintiff, at the suggestion of her attorneys, went to see him back in 2018. Between 2018 and 2022, she went to see him about twice a year. All of a sudden, at trial, he testifies that she needs to see him or a doctor like him 16 times a year.
So that's true, and that was in the life plan that Dr. Guy submitted and discussed with the jury. And then you had an opportunity to put on doctors who testified differently. The jury sat there, they thought that Dr. Guy made a good point that in the future, because she is now 10 years older than she was when this accident happened, she might need this. Why would that not be something that, look, that's what the jury decided, why should we be tinkering with it?
Well, this isn't just a matter of, you know, their expert says one thing, our expert says another. This is a matter of his testimony is just completely speculative and not supported by the record. When he was asked why she would need...
Let me just ask you on that point. The record says she's been seeing someone twice a year. And he decides, just because we're all getting older, that goes up to 16 times a year? That's it. There's no other evidence in the record that she ever saw anyone 16 times a year from the date of the accident.
No.
Right?
And also...
Let me switch. May I ask you a different question? What about the home health aide for her life? Was there any documentary testimony other than we all get old and at some point we all would like to have a home health aide that made this person different for a home health aide for the rest of her life at approximately $850,000?
No. Actually, the plaintiff had a prior back injury back to 1995, and she was out on disability and never needed a home health aide prior to that.
Well, the home health aide was, the jury specifically said for 6 years, not for the rest of her life, right? That's what the verdict said.
Correct, but
the testimony, wasn't the home health aide testimony in connection to her needing additional surgeries?
But the testimony from Dr. Guy as to the home health aide ignored the fact that the plaintiff was able, she was caught on video, actually, surveillance video, performing tasks that he said she would have difficulty doing. She was carrying a full laundry bag. She was gardening. She was taking out the garbage. She testified she could do these tasks herself. Also,
Again, this was prior to the surgery. As my colleague just stated, that the home health aide was based upon the need for the home health aide after the surgery.
but he also...
The future surgery.
He also conflated her lower back injury with her neck injury because he said, when he was asked why would she need a home health aide, he said, well, she needs to avoid bending over as much as possible. That's a lower back injury. That's not a neck injury.
As opposed to the cervical injury, which you're saying, which the testimony shows may have come from this accident, not the lower back injury,
Well, did
which
he-
was a claim she had withdrawn, right?
It's the claim that she was
Did
withdrawn.
his testimony specifically say that it was relating to lower back injury?
No, he said the home health aid was only related to the neck injury only, but then he testified that she would need a home health aid to help her with tasks, and he couldn't differentiate between whether that difficulty was the lower back or whether it was the neck. He said, oh, it's only the neck only, but then he said, well, she needs to avoid bending over. Well, is the bending over from
did
the
she-
lower
did
back
he-
or is it from the neck?
Did he say that she needed it for 6 years or for the rest of her life?
I believe he said she needed it for the rest of her life,
Right.
and then the
So,
jury
so continue with Dr. Guy. The jury had already eliminated $700,000 from his life care plan, right? It was supposed to be 1.9, which they requested a total of 1.9. So do we know whether the jury's elimination of that had anything to do with this psychiatrist's,
Physiatrist.
I can never do that, right? Physiatrist's, those visits?
I have no idea whether that was a factor or not. But I'd just like to address one other thing. It's one of our other points, and I'll elaborate more in my rebuttal. Costco was severely prejudiced by not being able to question the plaintiff or Dr. Guy on the withdrawn lower back claim. The plaintiff proceeded. This case was primarily a lower back case, a lower back injury case. And it was only after the plaintiff got caught willfully concealing the prior injury that she withdrew it.
Right, so what was the basis for the court's allowance of that, to reopen, allowing the plaintiff to reopen her case to present additional medical bills?
I'm sorry?
What was the basis for the court allowing the plaintiff to reopen her case in order to submit additional medical bills?
There wasn't that's another issue where she was able to reopen the case after she rested. She was able to reopen her case to submit an additional medical bill. There was no real explanation why they just discovered that bill at that particular point after they had rested on their case, and why it should be reopened to introduce that bill. I believe that bill was $71,000.
$71,000, yeah.
And I also believe there's some overlap between whether it was for lower back or
Right, that was, yeah, because you were discussing that, that's what
Mr.
prompted me.
Wallace, can I ask you one other question? So are you asking us to completely set aside this verdict, to send this back for a new trial, to reduce the verdict? What is your ask here?
The ask is to set aside and send back for a new trial, or any alternative to reduce it to a more appropriate amount.
Did you give a number? You didn't, okay.
Thank you.
Thank you.
Good afternoon, Your Honor. Good morning, Your Honors. Julian Rosen for the.
You're used to saying good afternoon.
Right.
Good
Thank you.
morning, counsel. Can we talk about the home health care and the testimony relating to that, and whether it was in fact related to the neck and future surgeries, and that the jury awarded it not for life, but for 6 years?
Yes, I mean, Dr. Guy admitted that his entire life care plan was about the neck. We said that at 546 of the record. So we know it's about the neck. And it was for 6 years.
No, he didn't ask. He asked for
he said-
lifetime.
yes, but the jury-
Lifetime.
Correct.
He said she needs this for the lifetime.
right.
Was there any support in the record for 6 years as opposed to lifetime?
I'm not sure if there was support in the record. However, it's substantiated because Dr. Guy testified that this injury is never getting better. It's permanent, it's progressive, and she will need, it's called adjacent segment pathology, and she will need another surgery in the future, which will not just be a 2 fusion surgery, it will be a 3 to 4 fusion surgery. It's a different surgery. And so he did say, and we acknowledge, my adversary makes a big deal about the surveillance. Nobody says that she couldn't garden and carry laundry. This isn't about that. This is about how an asymptomatic degeneration in a 56-year-old, which is no surprise. I'm sure the backs of 56-year-olds, most of them are riddled with degeneration, unfortunately. This was quiescent and asymptomatic. And this fall brought on and caused her injuries.
So, counsel, is the household help award defined or circumscribed by the surgeries? In other words, she will need household help at the point in time where she has replacement surgery, or was it household help from now until?
It appeared to me from his testimony that it was in the future, based on the injuries, based on the fact that it won't get better, and based on all the attendant circumstances and sequela from her condition progressively getting worse. And
So how many years did he, I mean, he came
20
up with $850,000, right? How many years?
820, over 825. But I don't understand. How could you state that it's going to be sometime in the future?
56,
Right.
65. yeah.
or she's 65.
65.
So doesn't that, and how many years did he say she would need it for?
Well, I think he said for the rest of her life.
Right,
Right.
which is
Which-
20
The 21 years was the time,
right?
Right.
was the number.
Was the 21 years was the number. So
So it couldn't have been just for the surgery, because she's not having the surgery for another 10 years, right?
correct. It was
So it has to be now.
has,
So it has to start now.
starting now, right, starting now. And
And what about the evidence in terms of her abilities to perform what you say, routine, but still, based upon the surveillance, taking out the garbage, doing gardening, et cetera?
I think that it's related to the fact that his testimony is that she need help doing everything. That she needs assistance, not that she can't do it, that she needs assistance doing it. And the jury, mind you, the jury awarded $251,000 when Dr. Guy and Dr. Dwyer had $825,000.
Right, but how is it not, how do we get from what they awarded not being something that was based on speculation, based on his testimony saying that it's for her lifetime, versus it being connected to the surgeries that she will have to have in the future?
I think because it's hard to understand exactly how they couch that and for what reason, but I just know from the testimony of Dr. Guy and from the from the testimony regarding this, it was about needing help on everything. And
So the last time she had the surgery, did she have a home care aide?
no, in 2017 she didn't.
She didn't have a home.
No, and I think no, she didn't. In
So let's say-
2017.
So why would we then think that she's going to need one now for the second surgery, which we don't know when that's going to occur? I mean, what would he base his determination on, given the fact that the last time she had the surgery, albeit she was younger, she did not require any assistance, but it's still surgery. What makes him, why would he now state that in the future when she has a surgery, she's going to need a home care aide for life?
I mean, that direct question wasn't asked, but what I can surmise from the testimony, in addition to the surgery that we don't know exactly when it is, but he did say that she needs it, and that it would get progressively worse. It's a permanent condition, and how with the original fusion, after the original fusion, there's more significant limitation of movement, and it's just progressively getting worse. I don't know, it was never asked, and there was no testimony countering that, so they had every opportunity to ask him. And
Well, there was testimony, right, that she was doing, literally, the 850 is tomorrow, I need a home health aide. And the only testimony in the record is a video of her doing everything she does tomorrow, right?
Yes.
So there was testimony that would undermine that conclusion. And the question is, what supports that conclusion, that tomorrow, for the rest of her life, for 21 years, she needs a home health aide?
I would only say, from his testimony, again, we don't have to repeat, is that she's
So it's
progressively
just
getting
because
worse.
he said so?
Well, but
Okay,
no,
that's it.
based on her, not just because he said, yes, he's a treating physician,
Yes.
but based on the fact that this condition deteriorates and gets worse in time, and she's already at whatever age she is, it's certainly not going to get better. That is,
So let's say, counsel, that we disagree with the verdict. What is your ask in that regard? Your adversary was asked the same question, which is to say, you recommend a remand or a new trial?
Well, I didn't even get a chance to get up on my appeal. I have to do that in reply. I'm a respondent with respect to this element. So to me, I think that nothing should be changed. In fact, the jury discounted the 700,000.
Just leave it up to us to decide whatever.
I don't think it should be moved at all. I mean,
Okay.
the 1.2, we asked for 1.7. This is, as a matter of fact, before.
Didn't you ask for an increase?
I'm sorry?
Didn't you ask for an
That's
increase?
her cross
I
appeal.
did on my
Oh,
cross
that's your
appeal.
cross appeal.
I would just ask before I sit that the case that's in my brief, Eularia, which is at 70 AD 3rd, 410, just for context. I understand what we're getting into here about future home health aid. I do understand that, and every case turns on its facts. In terms of the number, in 2010, 15 years ago, for 20 years future medical expenses and pain and suffering, the court, for these same itemized damages, the court sustained about 1 million. And so the 2.1 that is here, I'm sorry, the 1.2 that was awarded here on a $700,000 discount from what our life care planner and experts substantiated, in our opinion, should stand.
Thank
so
you.
I'll address my appeal on.
I'd just like to get back to the issue of the withdrawn back claim and why that was so prejudicial.
Can I ask you a different question? Can you address the medication, the $200,000 for medication, why you believe that that was not supported by the record?
Well, that wasn't supported by the record because the plaintiff's own testimony was she was getting by with over-the-counter medications. And then, yeah, basically. And then you have Dr. Guy say she's going to need, medication between $3,000 and $10,000 a year, and then her economist bumps it up to $10,000 to $12,000
For the rest of her life?
for the rest of her life.
Not just around the surgery?
No, again, for the rest of her life, even though she testified, and the same thing with physical therapy. She said after the surgery in 2017, she had physical therapy for around 6 to 8 weeks. She felt better. She was doing it at home. She was doing well, doing that physical therapy at home. And then he says she's going to need physical therapy for the rest of
Because this all ties into the fact that this is a degenerative condition, and she's getting older.
Exactly, and that's another issue, is that her neck wasn't primarily the focus of her treatment or her complaints in the beginning. And Dr. Guy was asked about this, and then he says, oh, there's an incubation period. But that's not a generally accepted theory, and his only example was a cold or hepatitis.
So to go back to what you started out wanting to talk about with the withdrawal of the back injury, I thought the court said you couldn't ask questions about the process of withdrawing the injury, but you could ask questions about the back injury. I'm not sure how you divide that up. And
Well, I think there's two different things. It's undisputed there was a prior back injury that she sustained in 1995. Right. She received workers' comp. She was out on disability. That's what we could ask about. But we couldn't ask about the fact that she had been claiming all along a back injury in this case and withdrew it, and that she was receiving treatment. When she was seeing Dr. Guy in 2018, she was still claiming a lower back injury.
You're
so we
saying
couldn't
that
ask him, how do you separate that out?
That went to credibility also, I guess.
Exactly. Thank you.
Thank you.
Unfortunately, I only have 2 minutes on my appeal, but I try to stay within the 2 minutes. So the jury awards $310,000 for pain and suffering, right? $250 past, $60 future. I understand that we didn't ask for inconsistency, but under Lind and Jeff and Scott gets posed, we know that we can, what's preserved is material deviation and against credible weight of the evidence. So here, that's our position. $60,000 for 21 years. If you look, and even if you find it excessive, the future medical treatment, and reduce it to whatever degree you may reduce it, the fact that the jury examined that element of damages and came to that award, which our position was substantiated by Dr. Guy and not disputed by the defendant, this is just grossly low.
How was it substantiated by Dr. Guy? What about his testimony substantiated it?
An increase in the pain and suffering award?
Mm-hmm.
Okay. Well, I mean, first of all, she had a two-level fusion. Two-level fusion, and so as you know, the case law commands numbers close to 1 million for just a herniated disc with a fusion surgery. Here we have a double fusion, and we have pain and suffering, nerve root damage. We have adjacent segment pathology where he says she's going to need another surgery. And by the way, Dr. April, who's defendant's doctor, admitted that in the future she will need adjacent segment surgery. He admits it. So we know that she's going to need the surgery. And so she has, the EMGs are positive, the MRIs are positive. She's showing more disc herniations after the surgery. It's not getting better. It's progressive. This will not change. And the surgery doesn't cure it. And this woman is going to be this way the rest of her life, not to mention her testimony, which is really...
So, counsel, let me just ask you, the jury could have, obviously, they saw the video of her living her life, doing her thing, and it's not clear that she would ever have surgery again. Maybe she won't, right? So, so there's a more substantial award for past pain and suffering, and then they see what she is, how she responds today, what she looks like today, what she's doing. They observed her demeanor, and they found that she was pretty much doing okay, right? That's not, why should we disturb that credibility?
Because it's not just about what she can and can't do. Again, we never said she couldn't do her laundry or garden or sit on the stoop and talk to her friends. It's how is she living with this? It's the loss of enjoyment of life while she's doing what she's doing. And if you look at her testimony at 137 of the record, she doesn't say things are great. And the surveillance is just on the very things that she says she can do. So the surveillance doesn't hurt me, us, the plaintiff.
Except for the household help, right?
I'm not sure that she wouldn't need things as she gets older, especially after a second surgery, but I would
The record was clear from both doctors, and when I say both doctors, the doctors testifying for the defendant as well as the plaintiff, that she will need future surgeries, right?
Yes. But at page 137 of the record, this is what she says, just quickly, if you can just let me do one. Okay. She doesn't say she's okay. This is what she says. Since this accident, I couldn't go to my mom's party. I have no life. I'm just home. Sometimes I cry because I'm in this crazy, what happened to me? I'm an independent person. I'm not a person who sits around and has people do things for me. I do things for myself. So here we have a situation where she hasn't even had the second surgery yet. So just because she's on a surveillance video doing things that she admittedly can do doesn't mean that she's not going to be irreparably damaged, which is the testimony shows.
Using Tylenol as her only medication.
Well, she eventually got to Tylenol, but she was on all sorts of heavy pain medications before.
She weaned off those and
She
went
did.
to Tylenol and was able to do these things?
She did, but if she has the future surgery, which not only Dr. Guy said she's going to have, but her surgeon, Dr. Gerling, it's in Gerling's records, which is in the record, that she would need another surgery and physical therapy and all these other things, then we're potentially going back up to the same very heavy medications that she required for her first.
The thing is, the jury did find that over the entire period of time, both before a potential surgery and afterwards, they kind of clumped it all together.
They did clump it together, but I would just respectfully submit that if you're going to reduce it, I don't have a number because I don't think it should be reduced at all. I would take into consideration all the attendant physical therapy and other, and it's in the, I'm not making this up, it's in the life care plan, what she will need in association with another surgery. It's a serious surgery. It's not even the same surgery that she had. So I would ask you to just look at that.
Thank you both.
Thank you. Thank you.
Macabi Management versus Kaban, 2356.
Good morning, Your Honors. May it please the court, Eric Sharp, on behalf of the defendants, appellants, F&M Funding, and Frank Palazzolo. Your Honors, I think the foremost issue on this appeal is that the court awarded the plaintiff respondent damages in the sum of $2,225,000. But the trial court provided no rationale in how it reached that amount. Notably, that amount is the exact amount that was proposed by the plaintiff in its proposed calculation of damages here, which was the plaintiff had proposed that the court take the difference between.
Counsel, isn't that usually the way it goes? Plaintiff says, give me judgment, here's an affidavit saying how I came to my number?
It is.
And did you put in anything to dispute any of the numbers?
Well, I don't know that I don't know that it matters because the court expressly.
Let me just interrupt you for a second, please. The way it works is the plaintiff makes out their prima facie case by an affidavit of a person with knowledge saying, here are the numbers and here's how I calculated them. It's not that hard. It's an agreement that has numbers in it. You could have taken out your calculator and done the same numbers, right? So now, let's assume that that's a prima facie case, which it is. What is it that you are saying is incorrect about that?
Well, what the plaintiff proposed was that the court compare the contract price for the property with the ultimate sale price at a foreclosure auction that took place 5 years later. But the trial court expressly rejected that, and that's
5 years later. They were trying to figure out what it was, at the time of the issue.
Exactly, and defendants had their own proposed calculation.
And what was that?
It was.
And was that submitted to the court during the trial, or
yes,
as post-judgment?
Yes, but it was also rejected by the trial court. But our proposal was that based on the financing being at 75%, that the fair market value of the house at the time of the contract should be the value that's compared to the contract price. And by our urged calculation, it was actually a number that was under the contract price. The court found that the plaintiff's proposed measure of damages was that the foreclosure sale was too attenuated 5 years after the fact.
Right.
But nonetheless,
What was the number that you gave? It was a big record, and I may have missed it. But what was the number you gave?
I understand the number. Which number?
The number that. What did you think the court should have calculated the damages? I'm sure you were hoping they wouldn't calculate the damages at anything. But assuming you had a different number, what was your number?
Our proposed damages were zero, and that's because the contract price of.
Well, yeah, that's. But okay.
And it was
there you go.
The contract price was higher than the fair market value at the time of the contract, and that was the reason why the damages would be zero. But the amount that the court did arrive at, $2,225,000, was the exact amount that you arrive at by taking the plaintiff's.
It wasn't $2 billion, was it?
Million.
It was 2.2.
Million. I'm sorry, Judge.
Yeah.
It was the exact number urged by the plaintiff, despite that
Right, but
they had
the court is
rejected.
faced with 2.2 versus 0. So, I mean, that's kind of a difficult calculation, right?
But the issue is that they expressly rejected that calculation, and they provided no rationale for how they did arrive at that same number. They simply rendered a verdict for $2,225,000, and after rejecting both of the proposed calculations by both sides, and gave no explanation. The second major issue is that the trial court awarded legal fees to the plaintiff in the absence of anything in any contract or any statutory.
I thought that the judgment never did award the legal fees.
She did. I don't know that it was broken down to an amount, but
The judgment did not.
The trial court judge did say in the decision in order that plaintiff was.
But in the ultimate judgment that the court, that was signed off on by I guess the county clerk, that's who usually signs off on the judgment, there was an amount for attorney's fees, separate amount for attorney's fees? I didn't think there was.
It was broken out, Judge. I'm sorry, Judge.
When you get your turn, you can answer that.
I'm sorry, I'm just fumbling here, but it was my understanding that that was a part of the actual award from the trial court, and that there was no.
The judgment would say, and blah, 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 in attorney's fees. So it's pretty easy to see whether or not there was. I didn't see it. If you see it, maybe you have a different judgment.
Well, the order says the court further finds that plaintiff is entitled to legal fees incurred in this prosecution of this action, right?
Correct.
But the judgment itself doesn't say. You have time on rebuttal, though. Thank you.
Thanks.
May it please the court, Claude Castro for the respondent. The issue beyond the amount of the judgment is a much more serious issue of fraud on the court.
Now, let's just go. How did your client come, how did the plaintiff calculate damages?
Your Honor, the court calculated the damages based on our argument that because there was tortious interference, this is not just breach of contract. She found his clients having tortiously interfered with our contract.
Right, and
There's
then
also
how did they
fraud.
find the damages based on that?
Honor,
Let's
if I may.
focus on damages, okay,
In
please?
addition to that, Judge, there was fraud on the court. And the measure of damages for fraud on the court, as Creon says, Court of Appeals, the court is free to get whatever damages she deems appropriate. They lied to 3 judges of the Supreme Court, Bronx County. They lied.
How did that translate to $2.2 million?
Because the court looked at the fact that we had a contract of $1,975,000. Based on their own conduct, they created a phony foreclosure in order to wipe our right of specific performance. And at the foreclosure, his client bid $4.2 million for this property, which means if our client had the right to buy it at the contract price, they could have sold it for $4.2 million at the foreclosure.
So that's what I'm just trying to get at. The court said that's the measure of damages. The difference between your number and the price that was the surplus from the sale plus return of your security deposit.
That's correct, Your Honor.
That's it.
And by the way,
That's- I
this
just
was
want to
not
make
for breach of
sure.
contract.
I just want to make sure that
Yes.
those are the numbers
These
that
are the
the court used. The
These are the
return of the security deposit and the surplus funds from this foreclosure sale, correct?
No, and the damages of $2.25 million. The surplus funds is a separate issue that is yet to be determined.
Okay, how did the court come out with 2.2? Where did that number come from?
You
From the
take
air,
contract pri- No.
Contract price
Contract
price was 1.
1.975 minus the sale price at the foreclosure, at the foreclosure of 4.2. That's that number. It didn't come out of air.
Okay, so it's
And that number,
4.2.
Your Honor, if I'm-
4.2 minus 1.9.
Correct.
So your damages were based on what you could have gotten
Correct.
had you gotten
Correct.
possession, which you never did, right? You never had
Correct.
possession of
And
the.
why didn't we? Why didn't we? This is diabolical. His client had the right to, he satisfied the mortgage, and then after he satisfied, he said, give me an assignment. He gave it to his front guy. They then went ahead and started a foreclosure. And what is diabolical, they kept it from 3 judges. We have it in our appendix.
So, counsel, let me
client
ask
and the
you,
lawyer-
counsel,
Ma'am.
let me just interrupt you for a second. Legal fees. Are you seeking still legal
Yes, Your Honor.
fees?
We have referred it to a referee in the court, and we're waiting for a hearing.
Ah.
Absolutely.
So there was no, I mean, the judge said you're entitled to legal fees, and the very common thing is that it goes out for a separate
that's what we
hearing.
did.
So that's good, that isn't even before us.
That is correct.
We'll be back on that one, but.
We'll be back, but we're waiting for a hearing. But what I'm saying, Your Honor,
Well, what's the basis of your claim for attorney's fees?
the court granted it, I think, because of the tortious interference and because of the fraud on the court.
Can you do
She
that,
determined
counsel?
what the remedy is.
Counsel, there's
Can
a
you-
question.
Can you do that in the absence of a contract that allows you to get attorney's fees?
Again, this was not based on the breach of contract. This was on the basis of tortious interference and fraud on the court.
So does the court have the right under any statute or law to direct there be legal fees based on fraud and tortious interference with contract?
I would refer the court to Creon's. Creon says, once fraud on the court is perpetrated, the trial court is free to determine whatever remedy it deems appropriate.
Did the court find fraud on the court?
I believe
Is
it
it,
did.
show me in the decision.
I think, Your Honor, it's part of the tortious interference.
No, that's
Did
a
she make
different
specific
claim.
finding?
That's
No.
yes. Okay, so
I agree
there's
with
no
you.
finding on fraud on the court. There's a finding of tortious interference with contract, which does not raise the ability to get attorney's fees.
Okay.
And there's breach of contract, correct?
That is correct. But
Neither one of, there's nothing in the contract that says that if I have to sue, I get attorney's fees, right?
I agree with that.
Okay.
I agree with that. But I just want to bring one thing. In terms of fraud, I think this court can take a look at the fraud that was perpetrated here. For his client and his lawyer to then conspire with the lawyer who's foreclosing on his own property, and we have emails, Your Honor. They had meetings together to coordinate how to foreclose this property to prevent my client from getting specific performance. I have never seen anything like this in 40 years of practice, Your Honor. This kind of repeated fraud. They lied to Judge Barone. They told him the option is incurable. We have emails. The holder of the option offered to terminate it in 2014. He said, no, give it to me. I need it to raise a defense.
Thank you. Thank you very much.
Thank you, Your Honor.
Your Honors, I think the problem here is that we're all left speculating as to the manner in which the court.
No, your friend stated it was the 4.2 minus 1.7 equals 2.2.
That arithmetic does arrive at that number, but that manner of calculating damages was specifically rejected by the trial court in that same decision where they awarded that amount. So by the language of the decision itself, that was not the rationale, and there is no other
So
rationale.
you're telling me when they submitted a judgment, which is what happens after the order, the judge said submitted judgment, you did not submit a counter judgment, or you submitted one that suggested the damages would be zero, which you knew was not what the judge was going to do after her finding on the facts? I mean, she made a finding, and you could have given a different number for damages.
We could have. I was referring to prior to the judgment in the order that there was no language provided to explain that number.
I'm sorry, I do not understand. I'm not understanding what occurred.
What's confusing, I think, myself as well, is that that number, 2.22 million, is the number arrived at by the plaintiff's proposal for how to calculate the damages here.
Yeah, this is after the judge made after Supreme Court made a determination that there would be damages, right? Is that correct?
That's in the decision in order that resulted.
Okay,
in the
and so then my colleague just asked, did you then propose anything other than zero?
No.
Okay.
No, but it's in the same decision in order where the judge stated that taking the foreclosure sale monies and comparing it to the contract price was not acceptable because the foreclosure sale was too attenuated from the contract.
Thank you. Thank you both. Same to you. Thank you very much. People v. Yousef Johnson. Yes, you may proceed.
Good morning, Your Honors. There's so much to say about the sentence here.
Could you make your appearance, please?
Oh, Sean Nuttall for Mr. Johnson from the Office of the Appellate Defender. There's so much to say about the sentence here. I want to start there and try to come back to our weight of the evidence argument later on or rebuttal. So the question for this court is, what is the appropriate punishment? And even the prosecutor below didn't think that the answer was 20 years. They asked for 15.
Well, does the judge have to abide by what the prosecutor requests after trial?
No, Your Honor, but the prosecution is not in the business of under-asking, and the question for the court is de novo, what's appropriate? And I think it is significant that they only asked for 15.
I mean, I read that too, and I was concerned about that too, but also there was a lot of acting out on the part of your client in the courtroom. It required 15 court officers to respond to it. The judge may have taken some, offense to what was going on in his courtroom. He tried the whole case. So that's something that also comes into play in this particular case?
Of course, Your Honor. Look, it's bad. It's certainly bad. My client regretted it and apologized profusely, and the judge credited it. So the question is, How much is that outburst
Counsel, at
worth?
what point did he regret it?
I'm sorry.
At what point did he regret his conduct?
At sentencing.
At sentencing, wasn't there another outburst? Didn't he have an altercation with one of the court officers?
There's very little in the record about what happened.
Wasn't there a problem with the people in the audience who were there to support him? Wasn't there a commotion?
There is definitely a commotion. He doesn't control the people.
So when
in
is
the
he
audience.
sorry?
I'm sorry.
When is he sorry then?
He expresses. Even the judge below, who does not like my client, credits the apology.
I don't think it's a liking or a disliking from a judge to a defendant.
I think
it was more about conduct.
It was the conduct in the courtroom, and in terms of the courtroom decorum. It's not. I don't like this defendant, or I like this defendant.
I
Certainly,
agree- I agree
likes or
with Your Honor.
dislike never enter into a judge's determination as to what the sentence is going to be. But again, you were
given
discussing.
that, Your Honor, I'm sorry.
You were discussing why the sentence should be reduced.
Courtroom conduct, the question is how much that outburst is worth. It seems like it was worth somewhere between 10 and 15 years. That cannot be the case.
Well, I mean, the sentence was 5 years over what the people asked for, so how do we get to a number of it being worth 10 to 15?
Sure. Well, let's add up. The co-defendant gets 5 years, right, for the incident involving violence and property loss. He's acquitted of the second incident. My client is not. There's no property loss. There's no violence in the second incident. But let's say that's also worth 5. You're at 10. The sentence was 20. Is the momentary outburst on a
So what do you
terrible...
mean, I'm sorry to interrupt you, what do you mean by there was no property loss? He stole the guy's property and tried to sell, they eventually got the property back, but it's not like he didn't take the property, right? So to say that there's no property loss because the police did a good job and got it back for him is tough.
So give it 5 years, Your Honor. We're at 10. I still don't understand how you get to 20.
Okay, so you're saying based on what the co-defendant was sentenced to for the same conduct makes the sentence...
Well, the co-defendant only goes down on one of the two incidents. So co-defendant goes down for 5. He's the muscle, right? And if you look at the video...
Who's the muscle?
I'm sorry?
Who's the muscle?
The co-defendant.
And wasn't the defendant the person who set up all the situations?
My client, Yousef, it's his outcalls that I think the Johns are setting up the outcalls, right? They're the ones paying money for sex.
But he's the one supplying, but...
Yes, that's
And
right.
he's the one who's doing the false pictures too, the photos that are not of himself, so that when he comes to the door, and in the first situation, the guy says, "Ooh," and tries to push him out. There's this whole altercation there. Isn't the judge entitled to say altercation with this guy, altercation in the court it's sent when the verdict is read, altercation when there's a sentencing?
Your Honor, the question is what this court thinks is the appropriate sentence. If you think the false picture is worth years...
No, that's not really the question. It's not whether what this court believes to be the proper sentence. The question is whether or not the sentence imposed by the trial judge was excessive. It's not what I would sentence the defendant to, because in all honesty, I might have sentenced the defendant to something higher than what this court sentenced the defendant to. But that's not the consideration.
Respectfully, Your Honor, I disagree. People v.
No, I
Brisbane, the
know
Court of
what I would
Appeals-
have done. So you don't have to disagree.
I'm
with
sorry.
I know what I might have sentenced this defendant to, so that's not the issue. The issue
This
is
court
whether
has broad
Counsel,
plenary
counsel,
power to reduce the sentence.
Counsel,
That is the
counsel.
I'm sorry,
see,
Your Honor.
Yeah, I was speaking.
I'm very sorry, Your Honor.
Yeah, I understand, you're passionate about your client. That's what you do. I certainly understand that. But when I'm speaking, or when one of the judges on the panel is speaking, you stop speaking.
My bad, Your Honor.
Okay, you're bad. Have a seat, sir.
May it please the court, Amanda Regan on behalf of the people. Addressing defendant's sentence, the aggregate 20-year prison term for multiple violent felonies against 2 victims should not be disturbed.
Do we look at what the sentences imposed for the co-defendants were, do we look at the fact that the defendant, I don't believe is a pred, he was not a pred, right?
I'm sorry?
He was not a pred, he was not a predicate felon, was he?
This defendant was not a felony predicate, but it bears note that there were two very similar incidents that were pled down to misdemeanors.
Pled down to misdemeanors.
They were pled down to misdemeanors, but the facts, as
Right, but
elicited
for
at the
purposes of an enhanced sentence, he was not a predicate felon.
No, he was not.
Okay, so then why then is this sentence, why then was the sentence imposed not excessive, given all of the circumstances? And also, you know, the people requested a sentence lower than what the court imposed.
Certainly. Taking the co-defendant issue first, Mr. Hyman was a first felony offender. He had no criminal record, period, no arrests, no misdemeanor convictions at all. His conduct, he was acquitted of the second incident, so he was only convicted of offenses against the first victim, Mr. Gomez, and he was not the initial aggressor. Defendant was the initial aggressor here. Defendant, as soon as Mr. Gomez saw defendant running up the stairs and realized he was not the man that he was expecting and that he had arranged to have this encounter with, he tries to shut the door. Defendant pushes his way in and starts assaulting him.
He was charged with acting in concert, so he was charged with the same thing. And what was he actually sentenced to, the co-defendant?
The co-defendant received 5 years.
Okay.
But I implore your honors to
Same judge?
consider. I'm sorry?
Same judge?
Yes, I believe it was the same judge. But I implore your honors to consider the fact that it was defendant who was the initial aggressor. He does have these prior misdemeanors for very similar conduct.
And also, you know, I brought up that there was some commotion and some outrage, but outbursts in the courtroom. But I also, in reviewing the sentence minutes, which I have before me, the judge also, during the sentence proceeding, mentioned that the defendant, during the trial, tried to influence the jury and it shouldn't be lost on the court. That's what the trial judge said.
Yes, the trial
That
judge
was
did
another
note
issue.
that. Yes, he said he specifically, although he believed that the defendant was engaged in the involved in the attempted jury tampering, he was not putting that belief into the sentencing decision. But that is important to bear on why the sentence.
That's what the judge said.
Yeah.
Yes, it is.
That he was not putting that in his calculus when he was making the sentence.
No, he did say he did not put that into his calculus. However, the judge did take into consideration the violent outburst, and as the judge said at sentencing, I'm paraphrasing here, but he said that the demonstrated level of violence that defendant showed him just how capable of violence he was, and it provided insight into the fear that the victims must have felt during these
So again, the people were aware of all of this. If the prosecutor was in the courtroom during the trial, and yet the recommendation for sentencing, the recommended sentence was lower than what the judge actually imposed.
Yes, ultimately, it's in the discretion of the judge.
Yeah, but not just lower, significantly lower.
It was 5 years lower.
5 years lower,
It was 5
right?
years
So
lower.
is there anything in the record that explains why the judge thought that 5 years was more than the people asked, which is like significantly more?
Well, the judge said that he ran the sentences consecutively to one another because each victim deserved
agreed, but
justice in their
still,
own right.
The consecutive, right, yes, because it's two different crimes.
Yes.
But why would the number be 5 years more than the people asked?
Yeah, why would the outbursts in the courtroom, why would that add up to an additional 5 years?
Because I think in this instance, the judge explained that in his 28 years involved in the criminal justice system, he had never seen such a violent outburst. He had never been required, or his clerk had never been required to hit the panic button in the courtroom, which was then flooded with 15 officers that it took to subdue the defendant. And then he has an outburst at sentencing. I'm sorry.
In terms of the standard, we really don't have to concern ourselves with that, right? We can look at whether, in fact, this sentence was excessive and not even have to determine whether what the judge did was wrong or correct, right?
Certainly, this court does have interest of justice jurisdiction to address
And why can't we say, based on the fact that the co-defendant received 5 years for the same conduct of acting in concert, based on the fact that the people requested 15 years, that this sentence was excessive?
Well, I would just note that for the top count alone, the defendant received a sentence that was a full 10 years below the maximum, and he received the aggregate sentence that he did receive was a full 5 years below what he could have, or I'm sorry, yeah, was still 5 years below what he could have received if he was just sentenced to the maximum on that top count.
Counsel, the defendant was out on bail during this time? Or was he being held?
I believe he was held.
And was there an issue about his refusing to come to court for his trial?
There was one date where he did refuse to come to court, but again, that was mentioned at sentencing, but the judge said not taken into consideration in the calculus.
Thank you both.
Thank you.
I'm sorry, you have rebuttal. I apologize.
Let me start quickly by apologizing. I didn't mean to talk over you.
No, it's quite all right. Again, I understand the passion.
And counsel, essentially you were saying that our review powers on excessive sentence is we can look at it anew. We don't have to determine that the judge did anything correct or wrong.
That's all I was trying to say, Your Honor. I have 2 minutes, and I would like to get to the weight of the evidence point. The prior misdemeanors are his only prior criminal record for which he got time served in the 2 nights that he spent in Rikers waiting for bail to be paid. That's his entire criminal history. This case, there is consecutive sentencing here. In case after case, this court has reduced sentences for consecutive burglaries. In particular, People v. Vega, 3 burglaries. The same judge here gave a 17-year sentence. This court reduced to 10 years. In Johnson, 2 burglaries. This court reduced a 7-year consecutive sentence to 5 years. In case after case involving more serious conduct for defendants with more serious criminal history, this court has reduced sentences to about the 10-year range, and that's assuming that you don't touch the first-degree burglary. So if I could very quickly, I'd like to talk about the weight of the evidence argument with burglary 1. Both the complainant and my client agree that the incident changed in the hallway when Mr. Gomez starts trying to close the door on my client. But the key moment is what happens at the entry to the building, not in the hallway. And the prosecution below clearly didn't understand that because they argued to the jury that burglary could be made out at either point. Pretty confusing. There's no real question that Yousef showed up at that door to exchange sex for money. He is a sex worker. Mr. Gomez paid $200 for a massage or sex. Mr. Bamber, the other complainant, admitted that he exchanged money for oral sex. Yousef's co-defendant says he's a sex worker. The trial judge says he's a sex worker. That is fatal to the burglary charge because that rests on the theory that he was not there to exchange sex for money, but rather intended from the start to rob Mr. Gomez. It's just not backed up by the record.
Impersonation has nothing to do with this.
I don't think so, Your Honor. We're making a weight of the evidence claim, and there's different inferences one can draw from that, including
I'm
the
sorry,
fact—
so counsel, is your argument that in terms of the burglary, the intent to commit a crime therein has to be formed prior to
Yes.
entry?
Under the prosecution's theory, if you look at the charge conference, this is set out
That's
in our
not what the
briefing.
statute says.
Well, you have to choose, right? What's the dwelling? And the prosecution here says clearly it's the dwelling is the building, not the apartment. This is laid out extensively in our briefing. They say repeatedly, no, our theory is the building. Then in summation, they mess with it.
So can't the intent be formed? So this is the incident where he's attempting to get into the apartment.
Correct.
And he's unable to get into the apartment.
scuffle at the
There's
door.
a scuffle, and then the cell phone is taken.
It 100% absolutely cannot because of the way the prosecution charged this case. If I could just finish the impersonation answer.
That's okay. Thank you very much. Thank you both.
Okay, thank you.
Tahari v. 860 Fifth Avenue.
Good morning, Your Honors. Menachem Kastner of Cozen O'Connor, attorneys for the defendants' appellants in this case. This is an appeal from an order of Judge Engoron, which denied our motion to dismiss the complaint the second amended complaint as against the board, and at the same time granted a cross motion for them to amend the complaint to assert a claim against Ryan Hagelin as the president and representative of the corporation. That's inconsistent, and we will get to that once you.
So I have to just ask you, starting out, right? There's a claim that you treated that the board of directors, I might agree with you that the board isn't separate from the corporation, and there's no possibility that one can sue one and not the other. But there is a claim that the board treated your client, or I'm sorry, the plaintiff, in bad faith. So my question to you is, differently from every other client with similar situations, I know you argue he admitted he had no basis for that. That's a summary judgment motion. My question to you is, how do you plead that claim?
How do you plead a claim against?
Yeah, I mean, Levin-Dusky, there's a million cases, and the fact that the problem is that the language is sort of loose and
Well, Levin-Dusky actually.
So let me ask you again, how do you think that that claim should be pled?
The claim gets pled against the individual defendants, each of them, and you then take depositions. They've taken 20 depositions here, and you find out who exactly was the person who did wrong, and that person, as a shareholder, as a director, has a fiduciary duty.
So you're saying
that is breached. I'm sorry.
You're saying that each board director should be sued?
The answer is yes. There's a
In that capacity?
Sorry, Your.
That's okay.
There's an Ohio case, the Flaherty case, where it is an excellent dissertation on this entire topic, whether you could sue a board. And what happens at the end of that case, the court says the plaintiff is complaining, how do I find out who the culprit is? And the court suggests you sue all of the all the board members, and you take the deposition, and you find out who it is. They did hear exactly that. They sued 14 board members. 2 of them were left in the case. 12 were dismissed because they couldn't prove the requirements of wrongful conduct. They did exactly what it is.
Did they have depositions to do?
Oh, there were 20.
They deposed all those people.
They deposed all of them. And if I may, great reading. Mr. Tahari's deposition, pages 158 to 175 and pages 183 to 193. In 158 to 175, he is asked by my colleague, one after the other, what did they do wrong? And on page 175, he says, I know of nothing that they did except that my lawyer told me to sue them. He is so.
I imagine he was designing clothes and maybe not working on the construction in his co-op.
Whether he was designing clothes, but.
No, but let me ask you this, counsel. So what if the board takes a collective vote?
I can't.
What if the board takes a collective vote that Tahari is going to be treated differently from everybody else? How does that change the analysis?
I'm not fine. The same answer is if there's a board collective vote, you sue.
And then every single board member is liable for their vote in favor of that.
Every board.
Is that what happened in Levin-Dusky?
Levin-Dusky actually supports. It says.
No, I just want to know. In Levin-Dusky, the corporation was sued, right? Through the board of directors.
Thank you.
Which is normally the way you would do it.
You would sue the board and the corporation.
Right.
I mean the corporation and the board members.
That's right. That's the way you're supposed to do it, right?
And
it's not that the board has a fiduciary duty that the corporation doesn't have. It's that the way you would do it is to sue the individual board members, and that was done here?
Yes. Your Honor sat on the first panel last year, and when 12 of the 14 were dismissed, and I tried to fight for the other 2 to get dismissed, Your Honor said it's a 32-11 motion. There's enough pleaded with, they're blocking. So they did what the courts have said. You sue the members, not the board. The board is not a juridical entity. There are 11 decisions in 7 jurisdictions. 2 federal court New York cases have all concluded that. And in fact, we cite the Stromberg case by Judge Leibovitz. He came down with another decision last week on the 9th of February. Name of the cases by Alice versus 10 East End Avenue owners, 65 Miss 3rd, 1202, February 9th, not even a week ago. And he raises the exact same issues they do. It says plaintiffs claim that this court in Dow and in Foos found that there is a cause of action. And he said, respectfully, The issue is not before the court.
Well,
No one-
Stromberg obviously, and whatever Judge Leibovitz's decision on February 9 are not binding on this court, right?
1,000% not binding.
Okay, so then we have to look, so we can look at Dow, right? That's one case.
Correct, but however, if I may, the board is not a juridical entity because the case law in the Court of Appeals, Community 7 Board versus Schaefer says you need a statute in order to sue an artificial entity.
And in Dow, essentially what the corporation was being sued for that clause of action, even though the case says the board has a duty not to act in bad faith, that it was meant, or the claim was against the corporation.
Correct. And therefore, they complied. And if you look at the RPA, real property law versus the BCL, real property, the legislature went and specifically put in 339 that the Board of Managers has to file with the Secretary of State that if they sue, they have an entity to sue. In the BCL, you look at Article 7, it's one paragraph after the other. Corporation can get sued, director can get sued, officer can get sued. Officer and director can get indemnified. You never see the word board member as to lawsuits, and that's intentional.
Thank you. You have time, rebuttal.
Thank you, Your Honor.
Good morning, Your Honors, and may it please the court. My name is Amber Will of Morrison Cohen on behalf of respondent, Mr. Eli Tahari. And I want to first focus back on Stromberg. That is the discussion of the trial court decision that looks at the other cases in foreign jurisdictions and some of the federal court cases.
Can I draw your attention, one, to the fact that the board acts for the corporation, correct?
Correct.
And if it doesn't act for the corporation, it's acting ultra-virus, correct?
Correct.
And your clients in this case have pled a claim that they were against each of the individual board members, that they were they acted in bad faith, right? So it's not like they don't have a remedy. They have a remedy here. So the question I want to know is, why are you asking us to create this new thing? What additional relief are you going to get with this new cause of action that didn't exist before this? At least not explicitly.
Of course, Your Honor. I don't think that this is duplicative of the fiduciary duty claim that's brought against the Dusages, which is the separate board members that this court had previously upheld.
Why not?
Because the Dusages had a breach of fiduciary duty, but because of the specific conflict of interest. They remained on the board, they did not recuse themselves, and the construction project that Mr. Tahari is trying to do by combining his two penthouses in the building was going to disturb their enjoyment of their apartment.
Okay, but couldn't you amend your complaint to plead that they acted in bad faith by singling him out?
It's not just the Dusages' actions, though, and that's the difference in this claim.
Right, so you could go back and replead. The question is, you're asking us to find a new cause of action, against an entity that in the past has only been thought of as the actor for the corporation. Mm-hmm. And I haven't seen any case that changes that view.
I think, Your Honor, it's not necessarily creating a new cause of action out of whole cloth. This court has accepted causes of action against a board just for the fiduciary duty on
right, but yes, that's what's said. But every one of those cases cites Lewandowski, which is a bad faith for acting outside of either ultravirus or for singling out a shareholder wrongfully. Right? Sure. Not just. Breach of fiduciary duty is much broader than that. Can we agree on that?
Yes.
So we have not said that in general, in any other context other than you singled out this shareholder in a way you shouldn't have. And we may have called it breach of fiduciary duty, but it's all back to Lewandowski, right?
It's back to Lewandowski, but it's called breach of fiduciary on disparate treatment, and I think that's the distinction. We have breach of fiduciary duty claims against the Dusages for conflict of interest.
Well, and I'm reading the first Tahari case where myself and Justice Scarpula sat on, and in that case, as was stated, is because their refusal was based upon the impact that the renovations would have on their own apartments.
Correct.
Okay, and we stated, and we also stated that the actions were not taken in good faith in exercise of honest judgment in the lawful and legitimate furtherance of corporate purposes, which is Lewandowski. So again, it has to be outside, there has to be some improper conduct as opposed to just merely sitting on the board.
Correct, Your Honor. And I think the improper conduct here that's being alleged in this complaint is different than what is alleged against the Dusages specifically. This court in the last appeal said that a corporation does not owe a fiduciary duty to its shareholders,
Right.
and therefore the corporation could not be sued on that basis. But there is a breach of fiduciary duty on disparate treatment, and as Your Honor mentioned earlier, it's based on the collective entity of the board. The board as a whole is voting and approving various projects within the community.
So could you talk about how the apartment consolidation of 1, 2, 3, 4, 5, 6 other, I don't know what to call them, it's not units because it's combos. How does that fit into the discussion that we're having now?
Yes, so that really shows the disparate treatment between the actions taken against Mr. Tahari and the other shareholders. In the complaint, we reference the various apartments that have been combined and how the actions taken against Mr. Tahari are very different from that. Every single time that the court, after they approved the combination of the apartments in 2014, every time that when Mr. Tahari came up to say that there needs to be some aesthetic changes that has to happen, please approve these revisions, the board said only if you increase the security from $3 million to $15 million, only if you go ahead and refuse your ability to use a service elevator, even though we have given that to other shareholders, only if you sign a financial affidavit. For years, there was amendment after amendment put upon Mr. Tahari to pay more money, to give more unprecedented authority to the board, to stop the project, to complete the project on its own timeline with a $2,000 per day penalty against Mr. Tahari.
Well, the per day penalty is not something that is unusual. A lot of boards impose a penalty per day.
Correct, but the amount of the penalty is the problem. Originally, it was $100 a day. Now it's $2,000 a day. It was a 2,000% increase just against Mr. Tahari.
So may I ask you?
Well, wait, Justice Gonzalez.
Thank you. The board president, was it the same person throughout who was the board was Mr. Hogland board president or a board member throughout the consolidation of these 6 combos?
Yeah, I don't believe so, Your Honor. I think Mr. Hagland became the board president in 2019, and that is another basis for suing the board as an entity because the board members are going to change. But the board is the entity that keeps records of the votes, the minutes, the agendas. They're the ones with the institutional knowledge as to what the board treated Mr. Tahari versus the other shareholders rather than the individual members.
So how does what you're saying now juxtapose with what your adversary said, which is that I'm sorry, I talk low. It's not you, it's me. How does what you're just saying now juxtapose with what your adversary said, which is that each individual board member has to be sued to determine who's the culprit? Are you saying that? Are you agreeing with that?
I don't agree with that, Your Honor. I think on the disparate treatment claim, it's not going to be against individual board members. It's against the collective whole of the board. Just generally. And because you have to plead with particularity for a breach of fiduciary duty, plaintiffs are not going to have the facts to plead that each individual board member is acting disparately against that individual plaintiff versus the rest of the shareholders in the building.
I guess my issue, though, is to say that the board has a fiduciary duty is to say a lot more than just that they can't treat one shareholder. I mean, fiduciary duties are not just that I have to treat one shareholder, all the shareholders. You're asking us to give a duty on the board separate that the corporation doesn't have that is much broader than just don't treat one shareholder more disparately than another, right?
I think it can be excuse me, I think it can be limited. If you're looking at Dow and you're looking at this court's decision in 6 East 72nd Street, both of those decisions upheld a claim of breach of fiduciary duty based on unequal treatment, based on treating the plaintiff fairly. Those are kind of, it's the disparate treatment kind of angle of breach of fiduciary duty rather than looking at conflict of interest, rather than looking at breach of fiduciary duty as a whole.
If we state that there's a fiduciary duty, we cannot limit it, right? Because in the future, another litigant is going to come and say, well, this is a breach of the fiduciary duty because of X, Y, and Z. So because it's a broad term and encapsulates a lot, it becomes difficult. I just wanted to state, in this case, you did commence the action against the cooperative as well as 14 current and former members of the board. Is that correct?
Correct. That was the original.
That was the original complaint. And okay.
Yes.
Thank you.
Thank you, Your Honors.
The problem with the argument that you just go against the board, there were members who voted in favor of Mr. Tahari. The deposition testimony, their own pleadings, the complaint. There were 2 members at that time who actually were in support. So what you're doing by getting this broad board being indicted or being accused, you're taking the good with the bad.
Well, that goes to your point that after depositions or the record, you make a determination as to who voted in favor of Mr. Tahari and who.
And you go after them. That's exactly it.
Well, but then again, just because you vote against does not mean, you may have other reasons for for voting against. I don't see how that comes.
That's why you take the deposition. I mean, the Dusages are in the case right now, and we hopefully will move later to get them out, because at the depositions, Mr. Tahari testified he doesn't even know who Mr. Dusage is. He has no idea what they had against him, whatever, but apparently, Your Honor, we had this colloquy at the first deposition. Your Honor said, hey, it's 3211. We got to wait to see at the end, and I will take Your Honor's advice. We're going to work for 3212. But right now, 20 depositions, tens of thousands of documents, hundreds of thousands of dollars spent by the co-op, assessments against people based on statements, his own sworn statement, on 3211.
No, but I mean, we're trying to figure out right now whether or not we should put a fiduciary duty on the board that the corporation doesn't have.
And I don't see how you could foist that on the board.
But how do you adequately, what I keep trying to ask you, how does the plaintiff's claim that he was disparately treated, because at the end of the day, the vote is a majority vote, right?
Correct.
So how do you protect his claim that the board mistreated him?
You name all of the defendants as all the cases, the federal cases have all said the same thing. You sue every member of the board. I'd hate to be on the board, because what you do is you sue every member, you take them as they did, you sit down. We gave them every alteration agreement, every combination agreement.
And then you sue the board, the corporation sue the board for an ultra-virus action, right? Which every board has the obligation, every corporation has the obligation to act in good faith. So if you're not acting in good faith, then it's ultra-virus. That would normally be the way it would go,
But the board goes to the initial question. That's not a juridical entity.
I agree. I'm just saying, the question is, how do you protect the plaintiff's right to bring that claim?
You sue all of the defendants, all the members, and you figure out.
Which is what they did here.
Someone had to vote against it. Someone had to bring up an issue. Listen, they came up with a claim against the Dusage.
What happens if everybody says, not me, not me, not me, not me, not me? I didn't do it.
There's an issue then. Somebody had to have voted negatively to stop it. And when you say, did you vote negatively? Why did you vote negatively? The guy would say either they were raising, there was a hoist going up here, they're adding a floor on the top. And what we have to take cognizance, and this is in Lewandowski says that when you move into a co-op, you give up certain rights. You're living in a small government at that time, and you're subject to the board of directors. And I have to state on the record, and you give me a moment, I represent boards. I've been on a board. I have never in my life seen a board so dedicated as the people on this board. 24/7, they're all partners in big firms, and they give their lifeblood. And this is what happens, hundreds of thousands of dollars trying to defend what I'm going to say is a bogus claim.
Thank you so much.
Thank you, Your Honor.
Vavar versus Citigroup Technology. Citicorp?
May it please the court, John Shore for plaintiff appellant. I'd like to address the Valverde affidavit and then go to the Gomes case, Your Honors. With respect to Mr.
Sounds like you need to
Valverde's...
talk louder.
Oh, I'm sorry.
Thank you.
Can you hear me better now?
Yep.
Okay. With respect to Mr. Valverde's affidavit, it's deficient in many ways. Never once in his affidavit does Mr. Valverde say or claim that plaintiff actually told him this information.
Well, I mean, it's interesting in terms of how it's worded, because I think he says it was reported, right?
Correct, Your Honor.
And that's a little strange that it would say that the term would be used reported as opposed to plaintiff told me.
Well, wasn't this, the original affidavit was in Spanish, and it was translated, right? I mean, so I'm not fluent in Spanish, and I couldn't understand exactly what it said, but that's part of, I guess, part of the problem here, or maybe could be part of the problem.
There could be several problems with the translation.
Well, let me just ask you, is it reasonable to read the affidavit as saying that the plaintiff told his supervisor, I jumped off the, is that an unreasonable interpretation of that?
It's not an unreasonable interpretation, but it's
So
an
doesn't that
inference.
raise an issue of fact as to whether or not that's the plaintiff's, the sole cause of his accident?
Respectfully not, for
Why?
a few reasons. First
Why?
of all, again, when you do affidavits, and I've done many, it's very simple, and I have Hispanic-speaking clients with a translator, and
Spanish.
I told, or I was told, this reported does not
But
satisfy
isn't the reported, when you look at it in the context of the affidavit, he says, I went to see him, and right after that, he reported that this was what happened.
Actually, you don't even know when. First of all, it says after I...
Yeah, but those are all issues of credibility. That doesn't mean, look, said that you could, that's your argument to the jury, that isn't it weird that the guy said reported or whatever. Sometimes I use language. My husband uses Latin all the time. No one uses Latin. But that doesn't mean he's not telling the truth. The fact, that's a credibility issue.
But it will not defeat the hearsay exception.
It's his statement. It's a party statement.
It's a party statement, but first of all, with respect to the Gomes case, which the lower court relied on, the lower court said it was not a statement against interest.
Are you disputing that it's a party statement? It's his statement to the other party. Is that not a party statement?
It's a party statement,
So
but
why
it's not.
is that not
But even if you accept this affidavit, and let's say it was in proper form, and he actually said, Vavar told me, rather than it was reported.
Wait, I'm sorry, should you, just let me finish. I'm sorry, what were you gonna say? Even if you accept it, go ahead.
Let's assume that the language said, Mr. Vavar told me.
No, Vavar is the one who's reporting.
Right, rather than it was reported.
You ain't saying Vavar said, Mr. Vavar. Okay, I'm sorry.
Right, I apologize.
No,
Your
it was
Honor.
me. Go ahead.
That's all right. That in no way creates a material issue of fact, because all it says is Mr. Vavar reported that on his last jump, he fell to the ground, lost his balance.
No, he had been
and fell
descending the
backwards.
ladder, and he jumped the last rungs of the ladder. And so he jumped as opposed to descended, and also, which would be in direct contradiction to his statement as to how the accident occurred.
Well, first of all, Your Honor, he said, then in paragraph 15, then he goes to and we go to paragraph 16, it just says, Mr. Vavar reported that on his last jump, he fell to the ground, lost his balance, and fell backwards.
Yes.
Again, first of all, that does not, under the Lynn case of this court, the Wazalewski case, and the Marino case, where even if the foreman, in those cases, the foreman claimed, plaintiff told me that he slipped from the ladder or he lost his balance from the ladder, that does not in any way controvert or dispute that my client, under those cases, was struck by this object.
No, he claimed that as he was removing the ductwork, it caused him to lose his balance and fall off the ladder. Wasn't that his claim? Which is entirely different from he's going down the ladder and he decides to jump.
It does not dispute or address, like in Wazalewski or the Lynn case, that my client was not struck, which caused him to fall off the ladder, whether he jumped from the ladder after he was struck by it. There's nothing in this affidavit.
But it doesn't mention anything about the ductwork.
Because this affidavit was
in other words,
done
his
in
claim
response to a summary judgment
But his
motion.
claim seems to be that as he's trying to remove the ductwork, he loses his balance because he's trying to remove it and he falls from the ladder, as opposed to this affidavit, which seems to say he was just descending the ladder and he jumped and then he fell.
This affidavit was done in response to a summary judgment motion where the testimony, of course, was about the duct and that it caused him and the ladder to fall, but this affidavit is silent about the duct work having struck him. If there was a discrepancy, it would have been in the affidavit to say, hey, Mr. Vavar never told me that he was struck by a duct, which caused him to fall off the ladder and the ladder to fall.
Okay, Justice Gonzalez has a question.
Yeah, I want to go back to the question, the concerns with respect to the term reported that. Mr. Vivard reported that he was fine, reported that he had been descending, reported that on his last jump. So is there a parallel between how we treat statements in police accident reports and in ambulance reports and even in hospital records, where we draw a distinction between language that's written down that says patient fell on a sidewalk or was struck by a car, whatever, and patient told me that she was struck by a car, she fell on a sidewalk, or patient stated. Is there a parallel between how that type of hearsay evidence is treated and this here, reported that as opposed to said that or stated that or told me?
That's actually a very good analogy, Justice Gonzalez, because in cases, the Narvaez case, Narvaez, and the recent Barcia case, and there's the Rivera v. 972 Fifth Avenue, there was very similar situations where it was stated it was patient fell, and clearly the court, this particular court, said that that was hearsay. First of all, we don't know who the source of the information was, and even if this is a so-called affidavit and it was in proper form, the fact that someone says it was reported to me is not something that is direct information from the plaintiff himself. It could have been from a coworker. That's obviously, if they had an opportunity to do this affidavit, it is not a very complicated affidavit. Very simple. After the accident, I went to him. I saw Mr. Vavar. Mr. Vavar told me that he jumped.
Thank you. You have time
Thank
on
you,
rebuttal.
Your Honor.
Thank you.
Good morning. Nice to see everyone again. May it please the court.
By now, it is afternoon.
Yeah,
as a matter of fact.
It is.
It is
It's,
afternoon?
after
Okay, good
12.
afternoon.
It's after 12.
I stuck around long enough for it to be afternoon. Patrick Lawless for the defendant respondent. Mr. Vivaldi's affidavit does raise issues of fact as to the accident.
What do you say to the argument, because the word reported was used, that somehow makes this wrong or bad or an unfit affidavit?
I think it's just semantics, because he said the plaintiff, Mr. Vavar, reported. So it's not a question. It's not a question of where did the information come from. It's not like a hospital report where it says plaintiff fell and you don't know who provided that information.
Isn't it a question of where the information came from, because there's no receiver at the end of this, reported to whom, you know, where's
Well,
what is it? Is it as object?
If you look in the context of this affidavit, what he says is, I heard the accident, I immediately went over to him, and he reported that this is what happened.
You're filling in the blanks?
Well, no, is it reasonable to read the affidavit that way?
Exactly.
And is there
It's a
any
reasonable
question that
inference.
this is a party statement?
Yes, it's a reasonable inference, and it's also an
Well,
excited
one
utterance.
second, counsel, because in the record at 512, you made a distinction, or whoever wrote the motion made a distinction that this was not a party admission, but a different exception to hearsay. And you specifically made that distinction in the record at 512.
Well,
You said it was an excited utterance.
the lower court found, or the Supreme Court found, that it was excited utterance. The Supreme Court said it's not a party admission because it wouldn't have been against his interest at the time.
So that's a different thing, though, right? So
That's
there's a party statement and an admission against interest,
Yes,
right?
it's
So
a
my
party-
question to you is this a party statement?
It is a party statement,
But
and
in
there's
the
also an excited
record,
utterance.
counsel, in the record, your motion, you were arguing that it was not a party admission, but that it was a statement against interest, and you made that distinction as to why it wasn't a party admission at 512. So are you arguing something different now?
I'm not arguing something different. I'm saying that the Supreme Court found that it was an excited utterance, and that should be affirmed.
That it was an excited utterance?
I'm sorry?
That it was an excited utterance?
The Supreme Court said that statement, that the plaintiff's statement given to Mr. Valverde comes in under the excited utterance exception to hearsay.
And that's what you're asserting is the exception to hearsay right now?
That's what the Supreme Court found, and I'm saying that that was proper and it should be affirmed.
Okay.
Thank you.
Counsel, was this an excited utterance?
I'm gonna go with what counsel is relying on, and clearly this was not an excited utterance under the
40-minute break,
Gomes case.
Counsel, there was a 40-minute break, wasn't there?
Correct, Your Honor. And in the Gomes case, where it was, this court disregarded the foreman's statement. In that case, in the Gomes case, the foreman said, plaintiff told me that he fell while he was descending the scaffold, and that was contradictory to what the testimony was. It was an improper scaffold. In Gomes, this court said it was not an excited utterance because there was no foundation as to the plaintiff's mental state.
Okay, so if we decided that we did not think this was an excited utterance, I understand that's what the motion court found, but if we decide it was not, there was no argument made in the papers that it should get in through any other exception?
That is correct.
So
That's what they
can,
rely.
they're relying on the excited utterance because that's what the motion court found. Now, we're looking at it to see should we affirm that, and we're wondering if this really was an excited utterance. You're saying no, it's not, and if it's not, then it shouldn't go in because nobody argued in their papers that it should come in any other way. Is that correct?
Correct, Your Honor. It was an admission by counsel of that's what they relied on. It wasn't a party statement. It was an excited utterance.
So it is your position that we can look at the record and say, we think it's a party admission, so we're going to decide that, or you don't think we can do that because it wasn't argued?
Correct, because...
Well, wait a second. You're saying party admission. I'm saying it's a party statement. A party admission against interest is completely different from a party statement. Anything a party says to any other party is admissible regardless of whether it's do we agree on that? Regardless of whether it's against their interest or anything else?
Absolutely, Your Honor.
What I'm saying to you and what I asked you before is not, is this in a party admission? I'm saying, is this a party statement?
Not from that affidavit, because it is drafted in a certain way that it was reported. It never said, Mr. Vavar told me. It was reported. Who was it reported to? Was it reported also to someone who spoke English? Mr. Vavar speaks Spanish as well as this gentleman.
But the mere fact that it says plaintiff reported, does that not make it a party statement?
Not on that affidavit, Your Honor, because we don't know who it was reported to. Then it's hearsay within hearsay. Who told Mr. There's no evidence that plaintiff told Mr. Valverde what happened as to the accident. It was reported. It could have been reported by plaintiff to coworker 1, who then told coworker 2. That's a game of telephone. That's why they did not rely on that. Thank you, Your Honor.
Thank you. WV Partners v. Hudson Private.
Good afternoon, Your Honors. Kevin Fritz from Meister, Seelig & Fine on behalf of the appellant, Hudson Private. At issue in this case are 2 funding agreements pursuant to which the plaintiff, West Ventures, funded $5 million for 2 movies, Bombshell and Ghostbusters. The agreements do not specify whether repayments by my client Hudson should first be applied to the principal and then the interest, or first to the interest and then the principal.
So in a situation like that, where there is no specific indication, does the plaintiff then have the option to apply the payments to either the principal or the interest as they choose?
Not where there's a course of dealing or an intent or understanding to the contrary.
But I thought the course of dealing was really just one time before. Is that really a course of dealing?
Well, that's the only payment that was made. And also, in the record is a statement by my client that his understanding as the principal of Hudson was that the payments would first be made to principal.
But how was his understanding was based on what?
When the parties negotiated the agreement.
And wasn't that raised for the first time in the reply brief?
No, they were the moving party, so I put it in my opposition. So it was raised in response to their motion. They moved for summary judgment. In opposition, my client submitted an affidavit which said, among other things, Hudson's understanding was that the payments would first be applied to...
Otherwise, yes, he said, in my head, I thought this, but did he say anything about we discussed, or there was a document that showed, or anything other than it was my own subjective thought that that's how it was going to go?
Well, that's another reason why the judgment should be...
I just want to ask you, is there anything in the record that would indicate that there was a discussion about that, or any documents that would show that it was the parties as opposed to your client's intent?
We served discovery, and the court stayed discovery because this was a pre-discovery summary judgment motion. So even though we served discovery in order to elicit that testimony and get that evidence, the court prohibited us from doing that, which is another reason why this court should vacate the judgment.
Well, presumably your client has the documents and the testimony that he relied on to come to this understanding, right? What did he say in his affidavit caused him to understand that? Was there any specific conversations that he had? Were there any specific documents that he mentioned in his affidavit?
He didn't cite any affidavits.
Anything, nothing, except this is what I thought, right?
Right, but I should note, Your Honor, in reply.
And if he did have a document or a conversation in mind, he would have said that in his affidavit, wouldn't
Well, we did actually submit, there was a subsequent agreement pursuant to which, after we obtained a judgment against the movie producer, the parties agreed that if we collected the $5 million from our judgment debtor and we paid it to West Ventures, that would be it. There would be no interest. So
But that never happened. You paid them something, but you never
paid them something. But all I'm saying is that that is evidence that the parties' understanding was that if repayments were made, it would first be made to the principal.
Or couldn't that just be, let me just get some money in my pocket because cash is king? Right? That to me only says cash is king. I'll take whatever you can get me. Not that we all understood that this is the way the document was going to go, right?
It could, but I never had the chance to explore that because the judge stayed discovery. I should also note, Your Honor, the judgment, in their own calculations, they applied interest from Bombshell to their calculation of the debt for Ghostbusters. And in the appeal papers, they say, well, it must have been a typo. It doesn't work that way. Like, they made a mistake, and that reason alone, for that reason alone, the judgment should be vacated.
Does it change the bottom line number?
Oh, absolutely. That's not a large amount, but the issue I'm
Doesn't change
talking
the
about.
but I'm just saying, it doesn't, regardless of that number, it doesn't change the bottom, because it was for both, right? So if it was attributable to one and say the other, the bottom line number is the same,
It
right?
inherently undermines the veracity of their calculations.
So I asked this question an hour ago in another case. So in order to have a judgment entered, we used to do this, we were all there once upon a time too. What about a counter judgment? Couldn't you have submitted another judgment? Did you have an opportunity to, and did the judge just discard yours completely?
No,
or
in
what?
fact, what happened, Your Honor, was they submitted a proposed judgment to the clerk. The clerk bounced it.
Right.
They then submitted a proposed order to Justice Baroque. I wrote an email to Justice Baroque stating that the procedure was improper. And then what I just learned in the appeal papers is Justice Baroque's chambers called the plaintiff's counsel and had some discussion about how the judgment should be formatted or submitted, and I was not part of that communication, Your Honor. It was an ex parte, respectfully to Justice Baroque, improper in my view.
You have time on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the court. My name is Ashley LeBlanc. Is that better? Ashley LeBlanc for plaintiff respondent. As Your Honor mentioned earlier, this is not hard. This is 7th grade math. I'd first like to address Mr. Fritz's point about the question about the calculation of the damages in the first instance. If you look at the record at page 30 and the record at page 33, it doesn't take a rocket scientist to figure out that it doesn't, in fact, affect the bottom line. And the court doesn't require perfection, it requires proof. And that's shown in the Apple Bank case, where there was a question as to the proper application of interest and what the general rate was. And the court held that can be looked up from public records and
Let me ask you, when the judge says submit judgment, that always means it has to be served on the other side. Did you serve your judgment on the other side before you?
It was, first of all, I'm not sure that that's correct.
It is correct. You don't have to, you can say settle judgment, which is a different thing.
Correct.
But submit judgment, you always have to serve your proposed judgment on it. Did you file it before it was
It was
signed?
filed, yes. It was filed and on the docket for approximately 30 days.
Oh, before it was signed.
Before
Okay.
it was signed.
All right.
I think that it was resubmitted, possibly with a recalculation of the interest just to affect the time that had elapsed, but there was an opportunity for 30 days to object. As to any agreement, it was their burden, it was defendant's burden to raise a triable issue of fact. And what the defendant raised was a self-serving statement that said, well, we think that it should have been applied to principal first before
Was
interest.
there any course of dealing?
There was one payment that had been made on the first agreement that was made pre-default, and that one was applied to principal first. The other two payments were made after default.
You applied those to
and those were applied to the interest, correct. And as to any, agreement that there might have been, that was not raised in the lower court or even in the appellate brief as a reason for, in the initial brief, as a reason for any sort of understanding among the parties. And so the sole proof that they were relying on is just a general understanding, hey, we thought you would do it this way instead of
when did they
another way.
actually raise this understanding that there was
For the first time, and I think you were pointing to that a little bit earlier, was on the reply brief on appeal. And so that issue, we believe that argument is waived. The particular pages of the agreement that are referenced on reply were not cited to the lower court below, and they were not cited in the moving brief. And so respectfully, we would argue that that's waived under U.S. Bank versus DLG Mortgage 146-83rd 603. In any event, that's an agreement on those record pages, and so the court could decide that as a matter of law, and it doesn't require a triable issue of fact. I think the other point I'd like to raise is that the parties agree that there's money owed here. The defendant doesn't dispute that at least $5 million of the judgment is owed. And so even though we respectfully believe that the judgment should not be vacated or disturbed in any way, if the court were to find that there were an issue of law or fact, we would respectfully request that the court direct the trial court to simply amend the judgment under...
So you're saying fine in liability, but just
at least
recalculate for damage.
Right. So at least, well, liability is, there's no issue as to liability. There's only a question as to the calculation of the damages. There's not even a question as to what was paid or what the principal was. It's literally a 7th grade math question about should it be applied to principal first or should it be applied to interest first. And the law already provides the answer to that. When the agreements are silent, it's creditor's choice.
Thank you.
Thank you.
Actually, what the law says is that the court should do equity when there's no agreement with respect to how the payments are to be made. And the case they relied on, I think, was from Onondaga County, which actually says that where one of the parties specifies how it's to be done, that's what should be followed. And here, they set the standard.
Is that in writing, counsel, then?
I'm sorry?
When you say that when one of the parties specifies how the payment is to be applied, was that in writing as in, here's the money in such and such amount, apply it to principal?
They elected to apply it to principal when we made our first payment.
No, right. And then you assumed that it would continue thereafter, but that was post-default, right? That the payments were applied to interest?
Yes, but there's nothing in the contract which gave them any rights to do anything different pre-default or post-default. I would also note with respect to...
But I was asking, did you say in writing with the payment that was applied to interest, here's the money, here's my money, apply it to principal like you did before?
I don't recall if that was done, but also because we didn't have the chance to depose the plaintiff, I certainly would have asked him what his understanding was as to how the parties were to apply the payments. I never got that chance. With respect to counsel's statement, this is 7th grade math. If you look at page 30 of the record, they list the principal amount for the bombshell minus the $200,000 or so that we paid. And then there's just a round number of $3.5 million and change for interest. There's no computation of that. There's no amortization schedule. There's no calculation provided whatsoever. I didn't get a chance to examine them on it because it was pre-discovery. And so they submit a proposed judgment with this round number, and Barack just stamps it.
So it was, counsel
Judge
says it
Barack,
was
you-
filed,
Yes, I'm sorry.
filed for 30 days, right?
I'm sorry, Your Honor.
The counsel says she filed it before it was signed 30 days, and it was on the docket for 30 days.
Right, and I did object. I said the procedure was improper.
Did you send a counter judgment with different numbers, different calculations?
No, what I believe I wrote, Your Honor, was that there was no finding by Justice Barack as to damages anywhere in his decision. So they submitted these round numbers that didn't have any documentary support, and then the justice stamped it.
Thank you. Thank you both.
Thank you.
People v. Dane, Richardson. Yes, you may proceed.
May it please the court, Frank Shaw for Mr. Richardson. There are three main weaknesses in the prosecution's case. First, it hasn't explained how Mr. Richardson could have gone through all the searches in the precinct, central booking, the courthouse, and West facility without the cocaine being detected. Second, Officer Epps' testimony relied on the dubious claim that Mr. Richardson was able to take this package, which was somewhere between the size of a golf ball and a baseball, and insert it into his rectum in, and I'm quoting Officer Epps' testimony, no more than 2 seconds.
Counsel, is a defendant who's charged with, what would be a defendant with, is a person who's charged with a misdemeanor strip search?
Generally, you mean to say at the precinct?
Yes.
Generally not, and I'm not suggesting that there was a strip search involved at the precinct, but at the very least, there was like a pat-down involved there. And then
But that's not something you could like necessarily find, right, in a pat-down?
perhaps not, but then I would then point to the search at West facility where he was forced to take off all of his clothes except for his underwear, and then he had to go through a secure pass machine, which would then be able to look into the body cavities.
But the bottom line, counsel, is, excuse the pun, is that the jury heard all of this. They heard the testimony. They heard the testimony from the corrections officers. I think from your client as well. Did your client
That's right.
testify?
Yeah, Mr. Richardson
And
testified.
so it's an issue of credibility. They made a determination that the defendant, that your client did in fact possess the narcotics.
Right, that's all fair, and all of these points I concede were before the jury, but I think there are at least two reasons why this court's review of the evidence should nonetheless yield a different outcome. I think the first reason I point to is that this trial happened nearly a decade ago. Today, there's much greater public awareness of some longstanding issues at Rikers, issues that predate this incident, that would have affected the analysis.
Trust me, we were aware of issues that were occurring in Rikers in 2015 and prior to that. That's not the issue. Again, the officers, the corrections officers testified as to what they saw. One officer saw the baggie or whatever fall to the ground. Another officer saw fall to the floor, excuse me. Another officer saw another officer pick it up. So again, there was the testimony by these officers. The jury assessed the credibility of the officers in the testimony. There was an adverse inference charge that was given because of the lack of the video.
Yep.
So again, all of this was taken into consideration by the jury.
Sure. So I guess maybe 2 points on that, Justice Weber. So I think first, going back to just general public awareness, I mean, just in the past 2 years, there have been several high-profile federal prosecutions of Rikers corrections officers for smuggling contraband. So I think, for example, if a jury had that awareness, it might have been more inclined
I
to
don't
believe.
know that that would have been admissible.
I'm not suggesting that evidence would have been introduced into trial, but that would have been part of the general informational mix that these jurors might have had. just
Right, but
coming in.
obviously a juror is not to consider anything outside of the record and anything read in the media, et cetera, in making their determination as to whether the people have proven the defendant's guilt beyond a reasonable doubt.
And they would have been advised so by the judge.
Sure, fair point, but I do think, some of these things, you can't unring the bell of what you've heard, and this would have just been in the general background informational mix. But I don't want to fight too hard on that. And then I do want to just, the other point, well, I think there are certain things that weren't as heavily emphasized at trial, which I would urge this court to pay particular attention to. And the first one I already mentioned is just this idea. Officer Epps, if we're talking about credibility, he said that Mr. Richardson inserted this object in no more than 2 seconds. I think that by itself is quite hard to believe. The second point I would just emphasize again is the more background
I
fact.
thought there was testimony in some statement that the defendant might have inserted this prior to the altercation or the interaction in the hall where he was actually arrested he was detained for the possession of the marijuana.
Oh, sorry, I might have missed it. Could you repeat your question, Justice?
I thought that I saw something in the record where there was a statement that the defendant may have inserted this or had this in his anus prior to the interaction with the officers in the hall where he was arrested for the marijuana.
I see. No, not at all. There's absolutely nothing in the record.
So we don't know when he inserted the drug.
Exactly, yeah. And I think that's a weakness for the prosecution's case, not for us, which is just how in this 48-hour window when he was in continuous custody, how did he come across this package?
Right, we don't know.
Right, and I think that's just...
But we do know that at least the jury believed that it did fall from the defendant's rectum at some point when he was at Rikers, right?
Right, may I respond?
Yeah, yes.
Yeah, so just on that point, I do want to emphasize that this was a close call for the jury, right? The 5 days of deliberations, they asked for a clarifying definition of what does reason without mean. They told the judge, we can't reach a consensus, and then only after 5 days of deliberations, they acquitted on the top count, but then convicted on the lower count. And so my main submission here is that it would take only a small deviation from the jury's assessment of the evidence for this court to conclude that the conviction here was against the weight of the evidence. So this
No, they acquitted on the intent to sell.
That's correct, Your Honor, yeah.
So again, the credibility issue is still... what I'm saying is that means that they still credited the testimony presented by the people. The only issue was whether or not the defendant possessed this with the intent to sell or whether the defendant possessed it for his own personal use.
That's true, but respectfully, given the amount of cocaine involved here and the way it was...
I don't know. You could use a lot of it. But anyhow, you have time on rebuttal. A lot of personal use there. Days.
Good afternoon, Your Honors. Jamie Maston for the people. Yes, Justice Weber. I'm sorry. So the jury had ample reason to conclude that the object that two witnesses saw fall from the defendant's body did in fact belong to the defendant. And the possession charge here is akin to a snapshot. It asks the jury to decide whether at the moment we allege that the defendant possessed the item, whether he exercised dominion or control over it. In no way does the possession charge require the people to prove when, how, by what means the defendant may have acquired or acquired or obtained the cocaine. So all of those...
So there were erroneous markings on the vouchering package. Does that call into question the weight of the evidence here?
It does not. Those issues were fully and thoroughly aired before the jury, and they rightfully rejected them.
And the jury actually asked some questions about that. They wanted to look at that. They were concerned about it, I presume, and so they asked several questions.
That's exactly right. They asked a question. They asked to see it. The court appropriately responded to that jury note by opening up People's Exhibit 9. They showed them the labeling, and they took that into great consideration when they decided it. And that determination should not be disturbed, especially in light of the overwhelming chain of custody evidence that the jury did hear. They heard an unbroken chain of basically recovery of the item from testing to introduction at trial. And not only was that chain of custody unbroken, but each witness along that chain testified that what they observed in People's Exhibit 9 matched their memory of how they had encountered it, either by recovering it or by testing it in the field test in those procedures. So we have two witnesses, one of whom was completely neutral. She was a sanitation officer.
But
We saw this.
counsel, if we couple that with the cocaine not being discovered for what's 2 days, isn't that enough to say that the weight of the evidence goes in favor of the defendant?
It is not, because again, we don't need to prove the provenance of the cocaine. It's possible that he brought it in with him. Maybe he obtained it from another inmate. But those questions do not have to be resolved by the people in order to prove the possession charge. And in fact, the jury heard evidence that it was entirely likely that the defendant brought this in himself or another inmate brought it into Rikers themselves. Two investigators testified, and they each explained that they have been called to investigate contraband that passes central booking and goes into the housing facilities practically every week. They testified that there are search procedures, but none of them are 100%. They testified, quote, that it's an uphill battle to prevent continual contraband from entering into the facilities. And that's where the logic underpinning this argument actually fails, because what they're trying to say is that it must have been so improbable for any defendant to have brought contraband into Rikers that there's no reason to believe the two independent officers who saw this contraband fall from the defendant's body. And in fact, that logic doesn't hold in light of the testimony that the jurors heard here. Either of those two scenarios, what happened in the hallway or what happened in the search room, were independently sufficient to sustain the possession charge here. The fact that we have both, the fact that the jury heard both, simply removes any doubt that the drugs did in fact belong to the defendant here. I'm talking in broad strokes during this oral argument. Much of the detail is in our briefs, which I would point you to. The defendant's statement that he wished to squash this, his furtive behavior during the strip search, his testimony was wholly implausible. All of that the jury took into consideration and reached this very fair verdict, which this court should not disturb.
Thank you.
Thank you.
Just two broad overarching points. So the provenance, as my friend says, of the package here, that's not an explicit statutory element of the offense. But just as a logical, factual matter, in order to believe that he possessed or exercised dominion, to use my friend's words, he had to have at some point gotten a hold of this. And our main point is that in these 48 hours, he was arrested on December 10th. December 12th, he enters Rikers. And then December 13th, he has a court appearance, and then he's released. We have to accept the prosecution's case that there's no reasonable doubt here. You'd have to believe that he came up with this scheme to smuggle in cocaine when he was only in Rikers for one night. And he managed to do this, getting by all the searches that occurred along the way. The second point then I just want to make is that about this being a two witness versus one or a 1v1. I think it's very much a 1v1 here. Because Officer Powell, she testified that she saw a package dropped from Mr. Richardson's body in the hallway. I think that's perfectly consistent with Mr. Richardson's testimony, which is that this package didn't belong to him, and that perhaps this never comes out during the testimony, that during the struggle, perhaps Officer Epps pinned the package to Mr. Richardson while apprehending them, and might have dropped from him, or maybe even from Officer Epps' body during their struggle. You know, this all happened very quickly, so if Officer Powell easily could have mistaken where exactly, whether from Mr. Richardson or Officer Epps, the package fell from. So I think ultimately this comes down to a credibility battle between Officer Epps and Mr. Richardson. And I'm not asserting here that you have to conclusively believe that Mr. Richardson's testimony is correct, but I think all I'm asking you to conclude is that there is reasonable doubt that Officer Epps was not testifying correctly. And I think for all the reasons that we've given, with just kind of the impracticality of this scheme, the lack of the surveillance video, and all the searches that happened before, I do think that there was reasonable doubt, and that therefore the verdict was against the weight of the evidence.
Thank you. Thank you both. Wong v. New York City Employees Retirement System. Yes, you may proceed.
May it please the court. Good afternoon, Your Honors. Akiva Shapiro, Gibson, Dunn, and Crutcher for plaintiffs' appellants. This appeal is about preserving access to the courthouse for public servants who have long paid into public pension plans and who allege that these plans are misusing the assets entrusted to them in violation of their fiduciary duties.
So, counsel, I'm going to jump right into this because you're asking us to ignore Thole, the U.S. Supreme Court, that says that there's no injury if the plaintiffs in this case, for example, are recipients of defined benefit retirement plans. They're going to receive the same pension benefits irrespective of whether the investments of the retirement funds have experienced a gain or a loss, and the fact that your adversary, the briefs say the fact that this is going to be divested from fossil fuel-related securities and invested in green securities really doesn't make a difference because there's no injury here. There's no case, there's no standing, there's zippo, nada.
Sure. So that's exactly the right question, and a lot to say about that. But two quick responses. Number one, we embrace Thole. This is the exact error of the court below to rely on Thole. In Thole, Justice Sotomayor for 4 dissenters, but the majority did not disagree with this, that trust beneficiaries suffer a cognizable injury under common law the moment that there is a breach of the fiduciary duty.
Are these trust beneficiaries?
That is undisputed, yes. My clients are the beneficiaries of the trust. The reason that the majority went the other way in Thole is because it said under ERISA, federal statute that displaced the common law, federal standing requirements, you need that pecuniary injury.
What is the fiduciary duty the breach that you're alleging?
Sure. So the duty itself is that my clients have paid into this public pension.
Yeah, so they pick with one class. How come they pick fossil fuels? How come they didn't pick? Why are they not upset, for example, if they're investing in tobacco companies, or why that? So 2 questions. One, what's the breach if they're getting paid exactly what they would get paid no matter what the system, and why pick this? Why is this class of investments any different from any other?
And I just want to add, this is 2.7% of the portfolio, which I don't know, but I would think that there perhaps would be other portions of the portfolio which are larger. But please.
So the critical point here is that for a breach of fiduciary duty under New York common law, there need not be a pecuniary injury.
What is the injury?
The injury is that the trust beneficiaries are owed a duty of loyalty, that the single-minded focus of the...
What is, I still don't understand, what is the injury?
The injury is that there's a duty of loyalty, and that in deciding to wholesale categorically divest for political purposes, not because of risk-reward return evaluation, the mayor and the comptroller were very...
That's what you're saying? The breach of fiduciary duty is that the trustee decided one class of stocks are better values than another?
Are the breaches that they exactly did not do that. They did not do a risk return analysis. What we allege, and the allegations...
Well, they did a risk return, because the risk return, maybe you don't agree with it, but the risk return is that it's probably better for the environment if you go green as opposed, with fossil fuel versus green.
First
That's
of all,
the risk analysis.
our allegations are that they did this for political purposes. Second of all,
sometimes political purposes are good.
The thing is, there was a question, I hope you'll get to the answer, is what was actually the injury? I mean, it seems that the injury would be, oh my goodness, now I'm part of this fund and I'm getting a lot less money. But that was not an injury that they had. The money was going to be the same because it's a defined benefit pension. So what is, in the course of your answering, what's the injury that these people suffered, even if you're mad at the city for doing something that you don't like or your clients don't like? What's the injury at the end of the day?
So just to cover 2 things. The one injury which is recognized in Thole, if the common law had applied, although the court said that it didn't, was that when there's investment decisions that are made, that there's an interest, concrete interest that beneficiaries have in the assets of the plan, in the money, the body of the plan, the investments, and that what we allege is that by divesting wholesale from fossil fuels, they've lost out on significant returns. And although it's
You're
a
going to
fixed
get the same
pension
return.
plan,
See, that's what I do not understand. You get the same return regardless. You are insured, the employees are insured that they are going to get the monies that they put into the system, regardless of whether or not there's divestment or not. That's what I'm not getting.
And counsel, what trust are you speaking of? Isn't this a defined pension plan?
the assets of those plans, NYCERS and the other plans, TRS, that are the defendants here,
Are defined pension
they're defined
plans,
benefit plans, and we do
not trust accounts.
But there is a trust relationship which is established by the statute.
Okay, so you're using trust. You're using trust as a non-legal term, right?
Well, as there are trustees and they owe fiduciary duties to the.
That's not what we're talking about here. And so, what was the second thing you were saying on the under Thole? What was the second thing?
So the second thing is that this, again, I can't emphasize enough. The pecuniary injury is not our primary injury. It is the breach of the fiduciary duty. This court said in Miami Firefighters Trust pension fund case, quote, damages have never been considered to be an essential requirement for a cause of action founded on a breach of fiduciary duty.
So what would be the consequence of the breach of the fiduciary duty?
It would be, among other things that we ask for in our prayer for relief, an order that the plans conduct themselves in accordance with their fiduciary duties. In other words, conduct a risk-reward analysis when they make investments and divestments and not.
I don't understand you because there were two reports commissioned before this decision was made. One was done by Makeda Investment Group. One was done by BlackRock. BlackRock, investment and fiduciary analysis for potential fossil fuel divestment, and the one from Makeda has an even longer name. But so there was an analysis as to whether there would be a loss incurred in making this change and making this divestment. That's one thing that I'd like you to comment on. The other is that Thole says in the ERISA context, the fact that ERISA affords all participants, including defined benefit plan participants, a cause of action to sue does not satisfy the injury in fact requirements here. Article 3 standing requires a concrete injury, even in the context of a statutory violation. Now, in Thole, there was a right to sue. Here, there is no defined right to sue, so you really have to prove your standing, and I'm still not hearing the injury. Where's the injury in fact? It's hypothetical.
I'll answer both those questions, Justice
Please.
Gonzalez. So on the first question of the reports, those reports there's a motion to dismiss. They've made a motion to dismiss on legal grounds. They've introduced those reports, which are not part of the complaint or not incorporated into the complaint. And those are only cognizable if they're unambiguous, undisputed authenticity, and their contents are essentially undeniable. And they only defeat the complaint if they utterly refute the allegations. What we have here are two reports that are on their face marked as drafts. We don't know who received them.
Counsel, I brought up the issue of the reports because you said that there was that this was a willy-nilly political decision. So that kind of refutes the issue, what you were saying. But going to the issue of standing, I mean, you've been asked again and again and again, where is the injury? You know that if there's a problem with the funds, and apparently they've been performing well, especially in comparison to other plans, the average funding level of a U.S. public pension plan in 2020 was 56.2, and the lowest performing one was the NYCERS one, 78.1, TRS 80.4, BERS 94.1. What is your problem here?
So just on the reports, we don't even know that any of the trustees received them other than the comptroller. That's literally, we don't know that they even
You don't know
got
whether
them.
the trustees what?
Receive those reports, and the reports on their face say that the path that the funds would be best served by, that's their word, best served, is not total divestment. That's the option that the reports themselves recommend they avoid,
So
and that's
where
what
is your
they did.
injury?
And
Where is your injury?
injury is the very breach of the fiduciary duty. We allege.
What fiduciary duty? The people are getting their, do you say anywhere in your papers that their monthly benefits were diminished because of this? Are
No,
they
Your Honor,
going to
that
be
is not-
diminished? And they're also backed by New York City if there's a problem? So where is the injury?
The injury is, number one, they were owed a unbridled duty of loyalty by those trustees to invest in and to
So the
make risk
violation
return.
of the duty of loyalty is because they wanted to divest in fossil fuel. That's the violation.
And
you're
that-
against,
well, that they
and
made-
you're against it. You're against it.
That they
Because
made
you
the
believe
decision that
your clients believe in or believe that fossil fuel makes more sense or what have you than green gas.
No, Your Honor, that is not it at all. They want the.
So how did they breach the loyalty?
They want those trustees to make decisions based on what will generate the
Not on
greatest.
political issues,
Exactly.
that's what you're saying.
That's what
They
I'm
want them
saying.
to just make them purely on financial obligations. Think that's what their duty is to them.
Exactly, and that's, by the way, what the Northern District of Texas and the American.
No, I
Airlines
understand that, but again, I think the issue remains, and I could understand it if this were not a defined benefit plan. If it were not a defined benefit plan, then I would certainly agree. But again, the employees will be receiving the same amount regardless. But you do have time on rebuttal.
Okay, thank you, Your Honor.
Your Honors, may it please the court, Elena Drucker on behalf of the plans. Your Honors, the plaintiffs lack standing here. There's a lot of holes in the complaints, but that's the biggest one. We have a defined benefit plan. They will get the same benefits regardless. As
So
you
what do you
noted.
say to counsel's statement? Well, I don't need to show pecuniary loss. I just need to show that you breached your fiduciary duty to show damage, to show standing.
I mean, that's inconsistent with every single
Every
case.
single
of
case.
the New
Every
York Court
single
of
New
Appeals
York
and every
Article
everywhere else.
78 case, right? I
Every
agree,
single
yeah.
case. That's just not what I mean. Society of Plastics, which is a government case, says in it pretty clearly, we understand there could be a wrong. You need to have an injury. You need to be affected in order to have standing to bring the claim in front of us. The decision in Thole rejects the concept of using an analogy to trust, to common law trusts and private trusts, not because of ERISA, but
Well, that was
because
the question I had also, is this a trust?
this is a
So
contractual.
do we even get to the issue of a fiduciary?
Not a common law trust, right? A common law trust is a relationship where you get the corpus of the trust. The corpus of the trust is bigger, you get more.
Right.
The corpus of the trust is smaller, you get less. You have a direct pecuniary interest in it. Someone else is managing it for you, but you have an interest in it. They don't have an interest in the corpus. They have an interest in their benefits, and their benefits are undiminished.
And
Their
that's a
benef-
contractual interest.
And it's a
right?
contractual
Yeah.
interest under the Constitution.
Right.
That's what Scaglione and all those cases that they cite, but it's puzzling they do say that this is a contractual relationship that cannot be
Under
impaired.
the New York State Constitution.
Under the New York State Constitution, it's a contractual relationship that can't be impaired by the legislature and it can't be impaired by the courts because the comptroller or the city comptroller or the state comptroller is vested with investment discretion. And that discretion.
Isn't there already a legal mechanism for an adjudication of a breach of a fiduciary claims through the, namely the superintendent of financial services?
Absolutely. And that's the crux of this argument that this is government action. We should be able to sue without any injury at all. There is a robust organization set in place that involves the Department of Financial Services and involves a lot of regulations. I mean, there are lawyers that are literally their only task is going through all of those regulations that apply to those pension plans. This is a heavily regulated area. The fiduciary obligations are governed by regulations. Both the Department of Financial Services, which has administrative enforcement, and the Attorney General has enforcement authority. This isn't an area, and actually I think that that's another reason that the decision that for the Court of Appeals in the Society of Plastics is on point, because in there, the court also has this, there's a question raised about whether or not, if we can't sue, no one else can. And
No, but counsel, let me just ask you something. How do the petitioners redress their claim that the investment decisions are not being made solely in, which I can't imagine any company ever doing that, but just what's paying the most money?
Yeah, putting aside that there are deep problems with that view of fiduciary duties that I can just put to the side for a second.
What is their remedy?
Yeah, by design, we have political appointees who are elected at the helm of these public pension plans. If they disagree with how those things are being run, they can go to the ballot box, they can go to their elected representatives, they can go to DFS if they really think there's an actual breach of fiduciary duties, they can go to the Attorney General and say there's been a fraud. You know, if there was self-dealing.
Regarding the Attorney General, one of the things that they raised in their brief is that the Attorney General really is not going to sue on their behalf regarding a claim like this and hasn't done so.
Because there isn't a claim, right? Which is a really circular argument to say, well, look, if I had a strong claim, the Attorney General would enforce it. But because I don't really have a claim, the Attorney General is not going to enforce it. The case they rely on is the Consumer Union case about defrocking. That's a very specific situation that can happen, unfortunately, under New York state law, because the Attorney General is in the same position of defending our equivalent of city council, the state legislature. So in a case where the state legislature does an action that impairs a state entity, the Attorney General is in this strange position. But I'm from the Corporation Counsel's office. The Attorney General is not defrocked in bringing a claim against the pension plans for any kind of for the city pension plans for fiduciary duty. So that whole line of cases is completely irrelevant here.
Is there any argument, or is there any heft, I don't know, depth, something, to their argument that because the firefighters' pension plan and the police officers' pension plan voted not to participate, not to divest.
None at all.
Therefore, the other three should have done the same thing.
Right. When we're talking about investments, we're talking about a healthy mix of investments that can be made in a lot of ways. If there was only one healthy mix of investments, we'd all have the same investments and the same pensions and the same returns, right? You're talking about choosing from a big, big barrel of investments. And two of the plan's trustees decided not to even study divestment because they have a different plan. That's not a breach of fiduciary duties. That's just a question about whether or not this was not even about divestment. It's about the choice to even study divestment. They said, we're not going to study it. That's not a problem. They don't have to study it. But the decision about whether or not to make the investment is the question about the properness of it is about whether or not they have a healthy mix of diverse investments that are performing equally well.
Thank you.
And okay, I'm sorry, before I sit down, can I just address there's one misstatement or one case that I have that was discussed in the reply brief that I wanted to flag, which is to the extent that there are some cases that involve the plans that involve variable annuities, those aren't defined pension plans. So the cases that they cite on those, I haven't drawn that distinction, but those are just not defined benefits. So they actually are getting up and down in their benefits based on the performance of a plan.
Thank you.
Thank you. Just three quick points I'd like to make. Number one, Justice Gonzalez, the question you asked about the police and firefighters union is exactly the right question. It is not accurate to say that they were not there in the meetings, that they didn't consider divestment, et cetera. They were there at all the same meetings. They received all the same information. And they decided, and this is the quote, paragraph 26 of our complaint from Patrick Lynn, one of the police trustees, that every pension fund trustee has a fiduciary responsibility to act in the best interest of fund beneficiaries for the exclusive purpose of providing benefits. Our view on social and political issues cannot enter into the equation. That's exactly the problem here. And what the police and the firefighters recognize is that this was social and political issues entering into the equation. That's the breach.
They were free to come to that conclusion on their own. In other words, nobody dictated to them, and they didn't dictate to one another, right?
That's true, but to us, on a motion to dismiss, that's our allegations, that's the factual allegation that on the information that was presented and the analysis that they did, that the appropriate thing would have been to make that same conclusion. Number two, I think the question, I think it was from Justice Scarpula about what the remedy would be here, what the avenue for relief here is exactly the right question. The Court of Appeals in Stevens, in affirming this court's decision to allow forward a case without pecuniary injury, this is the DNA database case, the injury was relating to risk or fear about police action, said, quote, standing rules shouldn't be applied in an overly restrictive manner where the result would be to completely shield a particular action from judicial review. That's exactly what defendants are asking for here. There is nobody else. My clients are the individuals who worked for decades, subway operators, teachers who paid into these pension plans. They say that the plans are...
And they're getting what they're going to get, right? They're getting what they're going to get. They're not going to get a penny less than what they were going to get, correct? They're just unhappy with the type of investments made. And then another group could come in and say, we think the only responsible thing is to divest from tobacco, from this, from that, from the other. Everyone could sue on that ground based on their own political views.
And
right?
Respectfully, it's an extraordinary thing that the mayor held a press conference and said that we're putting our money where our mouth is on climate change using my client's money. And the court in...
No, you're not using a penny of your client's money. Your clients are getting their money.
As I stated, I could understand if this changed the amount that your clients are going to receive, but it does not. They're going to receive the same amount of money. Thank you both.
Thank you, Your Honors.
Taub versus New York City Water Board. It's the last case for argument. Oh, Ms. Taub, Ms. Taub, hello? Ms. Taub, so you stand there, right? And you have 5 minutes to argue. Whenever you're ready, let me know. So we cannot receive that right now. But again, you can, as I stated, you have 5 minutes to argue. So you just make your arguments, okay? Thank you. You're gonna need to bring the mic down when you get a chance. You have the microphone. You need to bring it down. Yeah.
Yeah, we need it.
1 second. 1 second, Ms. Taub.
Good afternoon, Your Honors. Thank you for giving me this opportunity.
So you're gonna have to, if you could speak a little louder, or if you could bring the mic closer to your face. There you. Okay.
Thank you for giving me this opportunity to present my case. My name is Hannah Taub, and I am the petitioner in this case. The issue before the court is the statute of limitation challenging the New York City Water Board decision should be valid.
Ms. Taub,
due to fraud and
speak louder for
concealment.
me? Can please? Thank you.
Due to fraud and concealment of critical evidence, as well as the board's failure to refund excessive water billing caused by a defective meter. Title 18, subsection 1341. Statute of limitation and tolling. Article 78 petitions are filed within 4 months of a final determination. However, exceptions exist where fraud and new evidence unable to be discovered earlier justifies the delay in filing. The final decision from the Water Board was in September 2014. However, crucial evidence, including a 2015 inspection report revealing the defective meter, wasn't made available until later. The concealment of the inspection report for over a year is a key piece of evidence that demonstrates DEP's deliberate attempt to avoid acknowledging their mistakes. They repeatedly ignored my request for the report and did not act on the information that would have shown the meter was effective. Additionally, the testimony from the inspector's report, which clearly identifies the defective meter, directly contradicts the DEP's claim that the charges were accurate. The DEP's refusal to issue a refund, even after the clear evidence was available, further supports my claim of fraud and concealment. Because the defective meter wasn't identified until 2015 and the DEP delayed its investigation while concealing findings, I could not file my petition sooner. The Water Board's actions effectively blocked me from discovering the cause of the overcharges, justifying tolling the statute of limitations. As Michigan Law Review and Clayton Act established, fraudulent concealment allows the extension of the filing period to prevent wrongdoers from evading accountability. This court has also recognized such exemptions as statute of limitations, such as the Riedel versus Riedel Washington Corporation, where concealment of facts led to an extension of time for filing. The DEP's deliberate delay and concealment in this case prevented me from having an opportunity to challenge the changes within the usual, to challenge the charges within the usual time. Therefore, equitable tolling is appropriate here, as DEP's action directly delayed my ability to act. In August 2022, the DEP finally informed me that an Article 78 petition was my recourse. I filed my notice of appeal promptly on December 20, 2022, well within the 4-month requirement. The DEP's failure to notify me of this right until 2022 caused a delay. Their continued misrepresentation and failure to correct the water billing also contributed to this delay. The DEP's refusal to acknowledge the meter defect, despite prevalence of defective DEP meters, constitutes fraud. They were aware that their new meters were sometimes found to be defective, but when I complained about my impossibly high bills, they refused to consider that the meter was at fault. The DEP's refusal to acknowledge the meter defect, despite clear evidence in their 2015 inspection report, constitutes fraud. Even after I procured the report via my assemblyman, the DEP still refused to issue me a refund for the overcharges. By concealing this information, they avoided responsibility for issuing refunds for overcharges. In New York versus New York City Water Board and similar cases, courts found that the Water Board must correct billing errors resulting from faulty meters. The DEP's deliberately concealment of the inspector report demonstrates their intent to avoid responsibility. Any reputable company that receives an overpayment can be trusted to refund it. It breeds mistrust to government agencies. When a government agency is dishonest and defrauds its customers, it is not befitting a government agency. I have included a timeline of events which shows how the DEP worked to delay and frustrate my efforts toward correction. I make several requests for reconsideration of the Water Board's decision based on new evidence and the meter defect. These were not delays, but valid attempts to revisit the case with new substantial facts that I could not have accessed earlier. The DEP delayed the report to give me the report over a year. The
Ms.
court.
Hobb, you have time on rebuttal. You do have 2 minutes on rebuttal, okay? So you can continue.
I respectfully request.
So let the attorney for the DEP speak, for the Water Board speak, and then you can speak again, okay? Thank you.
May it please the court, Lauren O'Brien on behalf of the DEP. The Supreme Court correctly dismissed this case as time barred. A final determination was issued in September 2014, and the Article 78 proceeding was not initiated until December 2022.
What about the fact that you determined that there was a problem with the water meter and that she was overcharged by $70,000 and then you corrected it? It seems fairly inequitable.
So I have 3 responses to that question. The first is that all that the record shows is that DEP found a defective MTU, but it's not, for the DEP's report doesn't make it clear that that defect caused any prior overcharging.
But it was 1 month that it was 10 times larger than usual, is that it?
That is not in the record. Neither sort of the discrepancy nor that the defect that was found caused any discrepancy. So all that's clear from the record is that DEP came and did an inspection, that it determined that there was a defective MTU and that there was a repair that was done at that point.
There was a repair.
There was a repair, but again, the second thing I'll respond to say is that this occurred in 2015, and still the Article 78 proceeding was not brought until
Also,
2022.
I thought there was something in the record that indicated that there was extremely higher use that might be equivalent to a leak of some sort.
So when the results of the DEP's inspections from the time that there were allegations of overcharging, the results were that the DEP concluded that the amounts being charged were accurately based on the water usage. There were allegations that, perhaps these were charges that could only be reasonable if there was a leak, but that is not what the DEP.
No, you surmise that might be a reason.
All we can say from the record is that the DEP took a look and did inspections at the time that those allegations were made and concluded that the charges were accurately based on that.
$75,000 for a water charge? Is that for the month or for the year?
I believe that's over the course of a number of years that she is disputing.
Is there not there? Yeah.
No, I thought she said the 75,000 based upon the incorrect reading on May 16, 2014.
That is based on, I believe, the disputed period is a period of beginning in 2009. So it's a
I see. So it's 2009 through 2014.
Oh, it's 70,000 between 2009 and 2000. Right.
Right.
Okay.
I'm fairly certain that's correct, but
So what kind of investigation, if any, took place? I'm appalled by the fact pattern here. The amount was such a high discrepancy between, it's just such a lot of money, especially when you're talking about a one-family house with 2 stories. I mean, the response period between the request for information through FOIL and finally a response only because the legislator in the area made the request. I don't get it. I don't get it. This is a consumer who paid the money over. You didn't even have to go after her. And then she says, you guys made a mistake. Look, your own people said this. And it was a defective meter and you had to replace it. What happened? Nothing, like Zippo.
So what I will say is that these are allegations about a number of years of which we don't have a lot of information about the house or the water usage at the time. And inspections were done at the time. And the defect that she's referring to here, it's not even clear what that defect was. She's sort of attributing this amount of charges.
Well, your inspector didn't say what it was. He said it was a defect, said what it was a defective, what is an MTU?
I'm not certain. I don't think it's the
Are you
same as
supposed
the
to
meter.
know?
But whatever the defect was, he stated that the defect would not have caused such an overcharge, right? Because I think you also stated that you're charged for the actual use, the actual water use.
And the point is there's absolutely nothing to indicate that this defect that was found and then repaired.
And the determination was made in 2014.
Correct.
She was informed in terms of when she could appeal the determination and the statute of limitations, and that did not occur until 2022.
Correct. And that,
Thank you.
again,
Thank you very much. So, Ms. Taub, you have 2 minutes in rebuttal. You can speak to anything that the attorney just stated, or you can speak further in terms of the timeline. But you have 2 minutes.
The leaks was checked by an inspector and he checked.
Make sure you speak into the microphone.
The leaks were checked by an inspector and there was no leaks, nothing, everything was solid. There were no leaks.
So, Ms. Taub, when you say $70,000, $70,000 was the amount from 2009 to when was
from
it?
2000 May 20, 2011. That's when they installed the meter.
Right.
And that's when.
Till when?
Till sky high. $56,000 for 2 years for 2 people occupying an apartment. I know that York versus DP had 4 tenants, families, was $4,000 for 2 years.
So it was
I need to-
2000, it was 2001 when they installed the meter.
2011.
2011, excuse me, until 2014.
So it's 5 years.
3 years.
3 years.
Oh, 3 years, yes. 3 years.
77,000 and change. And 75,000 was paid.
Right.
I mean,
And you paid that money in 2014
2014.
for those years from 2009 before?
From 2011.
I mean,
they-
2011,
The defective meter, they made it retroactive for 2009, but when they installed it 2011, you could see.
What
on
was the
bills.
normal, what was your normal bill
Normal?
prior to 2011?
A few hundred, 800. I have the whole list of all the bills.
And what is it now, now that they fixed it? How much is your
Now
month?
it's regular. It's 800, 900, 1,000, but not
per month?
56,000 for 2 years for 2 people.
per month for water?
800 per month. Right, okay.
And also over here in the September 2014, first of all, they didn't send me, I didn't receive the one that says that you have 30 days, but here it says very clearly that it's the actual is based on the actual recorded consumption. The meter, MTU is exactly, it tells them how to bill me.
Yes.
And this was defective, very clearly says defective.
Thank you both.
Can I give this for the? Thank you. I wanted to say that I don't want to.